Can you hear me, Vice Chair? Great. Good morning. We are on the record in case number 2021-00370, electronic investigation of the service rates and facilities of Kentucky Power Company. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission, and I will be presiding today. Joining me today virtually is Vice Chair Amy Cubbage and Commissioner Marianne Butler. For those in the hearing room, please set your cellular phones to silent or turn them off. We continue to take precautions in light of the recent increases in COVID cases, including limiting the number of persons in the hearing room, social distancing, and cleaning the witness table between witnesses. Disinfecting wipes have been placed at the witness table, and if any witnesses take the stand in person, we ask they wipe down with the disinfecting wipes at the conclusion of each witness's testimony. For those witnesses who will testify and counsel who will participate at this hearing virtually, to assist with audio clarity and avoid feedback issues for the video conference hearing, please do the following. Mute your microphone and turn off your video if you are not speaking. If you use a phone for the audio and a computer for the video, please turn off the computer audio. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. If there are multiple microphones, there will be feedback. Please use wired headphones or wired earbuds for better sound quality, and please do so also because of the risk of losing power depending on the length of the hearing. And then also please keep a charger nearby if your battery runs low. Finally, and most importantly, alert the Commission if you are experiencing technology failure that prevents your participation at any time in the proceeding. Attorneys should contact staff at the previously provided contact information. The hearing today is for the purpose of taking evidence on the AEP strategic review of Kentucky assets, ownership of Mitchell, the Mitchell Power Plant, including whether Kentucky Power has considered selling its interest to Wheeling Power Company and finding other capacity, the need for a CPCN even if West Virginia PSC approves Wheeling's petition, transmission planning and operation, and any other related matter. At this time, we'll have the entry of appearance of counsel. Given that this is we're conducting this half and half in person and through video equipment, I request that as each party's counsel identifies themselves and makes their entry appearance, that they also identify their witnesses. So for the for the company, excuse me.
Thank you, Mr. Chairman. Mark Overstreet, Stites and Harbison, 421 West Main Street, Frankfort, Kentucky. Appearing with me is Katie Glass, also with Stites and Harbison. The persons we have available to testify today are Brett Madison and Gary Spitznagel. Messrs. Madison and Spitznagel are appearing at the direction of the Commission to address the issues the Commission outlined for them to the extent they've been able to prepare and answer those questions. Mr. Madison also is available for questions concerning the four or five identified topics to which no particular witness was assigned in the Commission's order. Also available for questions that staff, the Commission, or the parties might have are Tim Kearns, Amanda Connor, Cameron Ali, and Alex Vaughn.
Thank you, Mr. Overstreet. For the Attorney General's office.
Mike West for the Attorney General's office, and I believe we have Larry Cook on remotely as well. And we have no witnesses.
Thank you. And for the Kentucky Industrial Utility customers.
Well, Your Honor, Mike Kurtz and Jody Kyler Cohn for KIUC, and we have no witnesses.
For the Sierra Club.
Thank you, Mr. Chairman. Good morning, everybody. Matthew Miller on behalf of Sierra Club. Also with me virtually is Joe Childers, co-counsel for Sierra Club. And we have no witnesses.
Thank you. For Walmart.
Good morning, Your Honor. Carrie Grunman with the law firm of Spillman, Thomas & Battle on behalf of Walmart, Inc. We have no witnesses today.
Thank you. And for Commission staff.
Nancy Vinsel, and participating remotely is Jeb Penny.
Thank you. Before we get started, I have a couple of questions for you, Mr. Overstreet. One is I just want to make sure we have it on the record. At the formal conference, you had indicated that Kentucky Power had entered into confidentiality agreements or non-disclosure agreements with the parties at that time. Since then, Walmart has filed their notice of interest to participate in this case. Has the company also entered into one of those agreements with Walmart?
Yes, Your Honor.
Okay, thank you. I've been advised that public notice has been filed into the record. Is that correct, Mr. Overstreet?
It was filed on Friday, Your
Okay.
Honor.
October the 1st. All right. And other than the application for declaratory order and the motion contained therein, are there any outstanding motions or petitions?
None to my knowledge, Your Honor.
Okay. All right. And Ms. Vinsel, has any, I believe that the public notice included information on how to participate should the public want to provide a comment. I believe it's also been noted on our website how to participate and provide a public comment in this case. Has anybody, has anyone from the public indicated their interest in doing so?
No, Chairman.
Okay. I'm going from memory here, Mr. Overstreet, but I think what we had discussed about process was that we would allow the company to effectively call its own, I know not its witnesses on behalf of its case, but to call the witnesses on its behalf and to give you an opportunity to conduct some direct examination if you would like, at least introduction of the witness, and then tender for cross-examination. Is that your understanding as well?
Yes, Your Honor. I would just note that to the extent that witnesses other than Messrs. Madison and Spitznagel, the other four witnesses, they are available for questions that anyone might have, but if no one has questions, then, you know, we're not proffering them for anything.
Okay, all right, that'd be fine. Is there anything that we need to take care of prior to beginning taking evidence from witnesses? Nothing from staff? Okay, all right.
Your Honor, if I might,
Please proceed.
one last thing. Mr. Madison, who's our first witness, in fact, did file direct testimony in the record, so I just wanted that noted.
Okay, thank you. All right, so Mr. Overstreet, you can call your first witness if you'd like.
Kentucky Power Company calls Brett Madison.
Okay, Mr. Madison, please turn on your video, turn on your microphone, and please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Please state your name and address for the record.
Brett Madison, 1645 Winchester Avenue, Ashland, Kentucky.
Okay. Mr. Overstreet, you may ask.
Thank you, Your Honor. Mr. Madison, what is your position with Kentucky Power Company?
President and Chief Operating Officer of Kentucky Power.
And Mr. Madison, on Thursday, September 30th, did you pre-file direct testimony in this proceeding?
Yes, I did.
And do you have any corrections or modifications to that testimony?
No, I do not.
And if you were asked those same questions here today, would your answers be the same?
Yes, they would.
Your Honor, with that, Mr. Madison's available for cross-examination.
All right, thank you. Mr. West, do you have any questions for Mr. Madison?
No questions.
Mr. Kurt?
I do. Good morning, Mr. Madison.
Good morning, Mr. Kurtz.
Will you turn to your testimony at page 10?
I'm there.
Okay, so on line 11, you're asked a question about what would happen if Wheeling Power decides to pay for the investments in ELG at Mitchell, even though Kentucky Power is not. And one ramification of that is that Wheeling could take sole responsibility for capital investments supporting ELG compliance. Is that correct?
Yes, it is.
Then you go on page 11, line 2. Logically, the cost of any non-ELG capital investments that are made and become operational before 2028 and continue to be used after 2028 would need to be fairly apportioned between the companies. What do you mean by that?
Well, what's meant by that, Mr. Kurtz, is prior to 2028, we, Kentucky Power, are undivided 50% owner in the Mitchell plant, and there are certain things that are required from an operation maintenance, could be some capital costs just to keep the plant running until 2028. Those investments, should the plant run after that, of course, without Kentucky Power, then those things have been bought, paid for, shared equally, and the plant would continue to run, but Kentucky Power would not be charged anything after December the 31st, 2028 for the operation of that facility. And these are non-ELG, as it says above, non-ELG investments.
Okay. When a utility has a known retirement date for a power plant, in this case assume 2028, wouldn't the utility taper down its capital investments in anticipation of the plant retiring in 2028?
Yes, we would begin what I would call a winding down period. I believe that's basically what you're referring to. If the end date is at the end of 2028, there would be a tapering down, a winding down period from our investment and our dollars expended in that facility.
And if Kentucky Power, let me start again, but if Wheeling was going to continue to operate beyond 2028, there would be no winding down because those capital investments would need to be made to keep the plant operational post 2028. Would you agree?
No, I wouldn't agree with that. If Wheeling is going to continue to be the operator of the plant beyond 2028, then Wheeling would need to fund whatever shares of the cost to continue operation of that plant beyond the date that we're winding down, because Kentucky Power would have no more use of that facility.
I agree on after 2028, but what about the period before 2028? In other words, if Mitchell's going to retire in 2028, won't there be less capital investments in the plant than if Mitchell was going to retire as late as 2040?
Well, I think you've got to look at it in a case-by-case situation. Depends on the capital that we're talking about. If it's something that's required to operate the plant in 2030 and that expenditure needs to start in 2027, then I think you've got to look at us being out of it in 2028 and what would be the pro rata share of our portion that we would pay for a 1 year period if needed. But if not, then that's Wheeling is going to have to pay for that. But you're asking me to kind of speculate on what that cost might be, and that's something that we'd have to just take a look at. But we would be in that winding down period.
I want to ask you some questions about the testimony of Mr. Becker.
Your Honor, may I rise?
Please.
Mr. Becker is not a witness in this proceeding, and his testimony in the CPCN case that Mr. Kurtz is referencing dealt with the Plexos analysis in that case and those results. And it was very technical, highly complex testimony. Mr. Madison, to my knowledge, was not referenced in Mr. Becker's testimony. And it would be inappropriate to ask Mr. Madison questions about something that a different company witness testified to. I'd also note that the Plexos analysis, as far as I could tell, was not part of the topics that the Commission identified in its September 27 order for discussion here today.
So I guess, are you objecting?
And so hence
Okay.
I'm objecting.
Okay. Mr. Kurtz?
I would like to ask Mr. Madison questions about this testimony, and to the extent he knows he can answer. Mr. Becker quantified in his testimony what he called the glide path winding down costs would be. And cumulatively, in excess of $30 million that Kentucky Power would save by not having to do capital investments on the Mitchell plant if it's going to retire in 2028. If it's going to retire after 2028, those 30-plus million would be charged Kentucky Power because they would need to be made so Wheeling could operate it, and so Kentucky Power would be prejudiced in excess of $30 million on his testimony by virtue of the fact that Wheeling wants to go beyond 2028, and this commission said no.
So given the fact that it does certainly implicate the portion of Mr. Madison's testimony and part of this investigation as to what possibly may need to change to the Mitchell operating agreement to ensure, I'll say it this way, the protection of Kentucky Power customers, I'll let the questions go, but it's a fair point, Mr. Overstreet, that certainly if Mr. Madison does not have firsthand knowledge and not comfortable answering the questions, his ability to say so, I think, will be important. His willingness to say, I don't know the answer, I think will be important for him to note since he may not have firsthand knowledge. But we'll wait for each individual question. If you'd like to object on an individual basis on each question or on a particular question, you may do so, Mr. Overstreet.
Surely, and of course, to the extent we have future hearings in this matter, Mr. Becker could be made available that would expedite and make this proceeding, today's proceeding, more efficient.
Thank you. Please proceed, Mr. Kurtz.
Thank you, Don. And I circulated this yesterday to council.
I got one.
I do too, thank you.
We have this Marcus Canyon C crossing exhibit 1.
So marked, cross exhibit 1.
Okay.
And this is already part of the record in this case, so I hope you don't take offense, Mr. Overstreet. I don't ask if you have an objection.
It is already part of the record. I have the continuing objection, if I might, to Mr. Madison being cross-examined on it.
That'd be fine. Noted. Mr. Kurtz, you may proceed.
Thank you, Your Honor. Mr. Madison, do you have this testimony in front of you? It was circulated last night to council.
Are you talking about Mr. Becker's testimony?
Yes.
No, I do not.
We can have it made available to him.
That'd be great.
If Ms. Blend could forward that to Mr. Madison, please. Okay. She's doing it now.
Okay. Mr. Madison, when you do receive that from Ms. Blend, if you could just let us know.
I've got it.
Mr. Madison, will you turn to page 7 of this testimony? I'm just going to read you portions and see if you agree, since it's not your testimony. Will you let me know when you're at page 7?
I am on page 7.
Okay. Page 7, line 7. If the company were to incur only the CCR compliance costs and retire Mitchell in 2028, customers would initially see a savings through 2027 versus the Case 2 CCR and ELG compliance option. This is largely because the capital investment for ELG compliance would not be incurred. In addition, the company has assumed in this analysis that other maintenance capital and landfill capital expense could be reduced in the 2023 to 2028 period immediately prior to retirement, creating customer savings. Do you agree with Mr. Becker's analysis?
Well, having not studied this and know anything about it, I mean, I'm assuming the analysis he did, as Mr. Overstreet referred to in the Plexco's model, is correct.
Okay. Page 13, line 3. I want to go through the same exercise. Well, line 1, what assumptions did you make about future incremental capital costs at Mitchell? And the answer is, in case 1, CCR and ELG, where the Mitchell plan is assumed to operate through 2040, the CCR and ELG compliance capital plus 100% of ongoing capital expense forecast were included through 2035. From 2036 to 2040, a glide path capital expense forecast was used where maintenance capital is reduced during those years as the 2040 retirement date approaches. This is what I want to ask you about coming up. Quote, for the case 2 CCR only compliance scenarios, 2028 retirement, only the CCR compliance costs were included, plus a glide path reduced capital expense forecast for the ongoing maintenance capital between 2023 and 2028. In addition, the ongoing landfill expansion capital, which would be required to operate beyond 2028, was eliminated entirely. Is that your understanding about what would happen with respect to capital expenses if the plant were to retire in 2028?
No, here's my understanding. That's Mr. Becker's testimony. But I just have to assume that it's accurate and correct because I'm unfamiliar with this. This is hitting me cold.
Would you agree that Kentucky Power consumers should not pay for incremental capital investments in the plant or at the landfill if solely because Wheeling wants to operate the plant beyond 2028 and this commission has determined that Kentucky Power should not?
I'll answer that this way, that in my mind, that if the capital expenditure is only utilized to operate the plant past 2028 and not for the benefit of the customers prior to 2028, I would agree with that.
Thank you. One last question on this testimony. This is Exhibit MAB-1, page 4 of 10. If you could turn to that, please, I'd appreciate it.
Is this on Becker's page 4?
Becker Exhibit MAB-1, page 4 of 10. It's a spreadsheet analysis at the back of his testimony.
Mr. Kurtz, I'm sorry, I did not catch the reference.
MAB-1,
Okay,
Economic Analysis Summary, page 4 of 10.
all right, thank you.
Just let me know when you get there, please.
Okay.
Okay, this is an exhibit titled Kentucky Power Company Case 2 minus Case 1, 2020 KEPCO CCR ELG plan difference between 12/31/28 Mitchell retirement and 12/31/40 Mitchell retirement. This is the base case with carbon commodity pricing. There were two other, and I'm not going to belabor the record, there were two other scenarios, one with the commission can look at this as well. One base carbon or base without carbon, and another run low band, no carbon. Well, let's just go through this base case with carbon pricing. Did you look at Mr. Becker's testimony back in the CPCN case?
Back in the original filing, yes, I looked at it.
Okay. Well, I don't think anybody would expect you to have it memorized, but if to the extent that you know, line or column 4 Mitchell fixed O&M and ongoing capital recovery. Do you see that?
I see it.
You see where there are negative numbers indicating savings of the
Yes,
2028? Okay,
the numbers in red, I see them.
okay. And then column 9, grand total net utility costs. This is a year-by-year savings of the glide path savings of retiring in 2028. Would you agree with that? Net of some smaller increases in other costs.
Yeah, the math looks correct, of course, without crunching the numbers. And again, this is Mr. Becker's testimony.
And then column 10, cumulative difference, where we see a cumulative difference reaching $30,671,000 in 2027. Do you see that?
Yes.
So does this indicate to you that there would be $30,671,000 of savings to Kentucky Power from capital cost savings from retiring the plant early under this glide path to retirement versus operating it or making the capital investments necessary to operate it past 2028?
I would agree that based on this analysis and the figures that he put in, that's what that says.
To use an imperfect analogy, if you know that you're going to retire your automobile in 3 years or 2 years or 3 years or whatever, you're not going to spend as much capital on it, new water pumps or whatever, if you're going to plan on keeping it for 10 years. Is that analogy as imperfect as it is kind of on point?
Well, I'm not sure if I agree with that or not when you're talking about running a power plant. I mean, I'll go back to what I said earlier. If the capital is exclusively for wheeling and only for wheeling to operate the plant after 2028, and there's absolutely no benefit for a Kentucky customer prior to that, then theoretically, wheeling should foot the bill.
Thank you. How would the commission go about monitoring, regulating this but-for analysis? How much capital is put into the plant that would not have been put in but for the decision to operate past 2028? In other words, how would the commission ensure that what you just said actually came to pass?
Well, I mean, I'm just theorizing here, but there's multiple ways that can be done. We can bring it before the commission during that winding down period and make it part of an operating agreement that such will happen.
Okay. And as you're not spending capital on Mitchell because the glide path towards closure in 2028, meanwhile, the net book cost is being depreciated each year through the depreciation expense that's built into rates, correct?
That's correct.
So if there were zero incremental capital spent on the plant, let me back up. Do you know what the annual depreciation expense on the Mitchell plant is for Kentucky Power?
Not off the top of my head, no.
Okay. In the last rate case order, the commission ordered Kentucky Power to file a rate case in mid-2022 for new rates to be effective 1/1/23. Do you recall that?
From our base rate case order?
Yes.
I'm not,
Yes, I do.
was that 23 to be effective 24? Or?
It was to be effective 1/1/23.
Subject to change.
It all runs together, but I think what you're asking is that the commission ordered the company to file a rate case at a date certain for rates effective on a date certain is effectively what you're asking, right?
Yeah, yes. Do you recall that, Mr.
It's
Member?
approximately 3 years after the order of the last base rate case order, January the 13th of 2021, as I recall.
21/22.
Of course, as you know, Mr. Kurtz, you back up 6 to 8 months prior to that. is when the filing would be done.
Well, I think Mr. Overstreet's right. I was wrong. It's 21, 22, 23, mid 23 to be effective 1/1/24.
Actually, it's Ms. Glass's.
Okay, thank you, okay. As part of that next rate case filing, would Kentucky Power consider recovering the, well, first of all, part of Mitchell fixed costs are recovered in the environmental surcharge, correct? The scrubber, I believe?
Yes.
Okay. As part of the next rate case, would Kentucky Power be willing to implement a Mitchell cost tracker, just like you have with your transmission expenses, so the commission could every month or every quarter or every semi-annual or every year track those declining rate-based costs from depreciation, which results in consumer savings, as well as to ensure that the but-for test is complied with. In other words, no additional capital expenditures are being charged to Kentucky Power that would not have been charged had the plant been retired in 28.
Excuse me, Mr. Madison, before you answer, Your Honor, I would object. The company really hasn't started sketching out what any future rate case filing would look like, and I think it might be premature for Mr. Madison to commit the company one way or the other.
I was just asking if you would be willing to consider that, a Mitchell tracker, just like you have a transmission tracker.
I'm not to quibble, I think the word was commit, but if I misheard, then
I'm sorry, I thought I said consider.
and you may have, I may have misheard, so.
So does your objection stand, Mr. Overstreet?
To the extent that the question would ask whether the company would commit to something in 2021 that wouldn't get filed for 2 years, it's objectionable.
And you're saying that's not necessarily what you're asking, Mr. Kurtz, is that correct?
Correct, consider, not commit.
Please proceed.
If you don't mind, could you repeat the question, please? It gets kind of confusing to try to figure out what the question is. I'm sorry.
It was a confusing question. Instead of recovering the balance of the Mitchell fixed costs and base rates, the non-environmental surcharge portion of Mitchell, would the company consider a tracker that recovered the fixed costs outside of base rates, like you have for transmission?
Yeah, I don't want to sit here today and speculate what we will or won't do. Till we get through and figure out exactly what that winding down period looks like, an operating agreement looks like, and start working through that, I can't speculate.
Okay. New line of questions. Kentucky Power, this is not a legal opinion, Kentucky Power filed a declaratory judgment action. Are you familiar with that?
Yes, I am.
Okay, asking the commission to declare that a CPCN from this commission is not required for willing to build stuff, invest stuff on the West Virginia Mitchell Power Plant. Is that your general understanding of it?
Well, my general understanding of the declaratory order is asking this commission to let us know by October the 8th if there is actually the need to require a CPCN, a public convenience and necessity, necessary to comply with U.S. EPA ELG rules from this commission to the West Virginia Commission. And that's the essence of what that declaratory order is in my mind.
Okay.
Besides, go ahead.
Let's assume the company is correct, that a CPCN from Kentucky is not required to build an ELG in West Virginia. Let's assume that AEP is correct. Does Wheeling Power need Kentucky Power's permission to do the ELG? As a 50% co-owner, do they need you to say, yes, you can build an ELG on my half of Mitchell?
Well, I think there's a hearing that has happened. I know there has been in West Virginia, waiting a pending outcome on October the 13th to see what that ruling is. And I think it's up in the air right now as to what's going to be required from the West Virginia Public Service Commission.
Different question I had though. Does Wheeling need your permission to build an ELG on your half of Mitchell?
Well, when you say our half, we don't really have our half. It's an undivided interest. And as you know, when you have an undivided interest, if you fill a glass of water up and you put 50% of your water and 50% of my water, it's our water. It's an undivided interest.
Okay. Again, assuming that AEP is correct, that a CPCN is not required from this commission, but also let's assume that Wheeling needs your permission to do the ELG. Would you agree that the commission has full, exclusive, 100% jurisdiction over the rates of Kentucky Power and the prudence of the management decisions of Kentucky Power that affect those rates?
Object, Your Honor, that's calling for a legal conclusion.
I tend to agree, Mr. Kurtz.
Okay, let me see if I can rephrase. I guess I don't really have an answer to the first question. Does Wheeling need Kentucky Power's permission to build the ELG on Mitchell?
Here's how I'll answer that question. Right now, there's things up in the air, i.e. while we're having this hearing, while we're waiting the pending outcome of the West Virginia hearing, and in a hypothetical, if West Virginia says press forward Wheeling with CCR and ELG, then the Kentucky customers, in our mind, will not be held liable for any expense required to perform ELG on the Mitchell plant.
Or for capital expenditures that would not have been made but for the decision to operate the plant past 2028, correct?
That's not what I said.
I know, but didn't you say that earlier, that if a capital investment was made solely for the benefit of Wheeling, that Kentucky consumers would not have to pay that?
That's not what I said. I think what I said was if there is a known capital expenditure that is going to be utilized only for the benefit of Wheeling to operate the plant past 2028, and that's all that capital expenditure is utilized for and will not gather any benefit for a Kentucky customer, I agree with you.
Okay, thank you. In terms of modifications to the power plant or the Mitchell operating agreement, does the Mitchell operating agreement discuss decommissioning expenditures and how those will be paid?
Your Honor, we've designated Mr. Kearns to address the operation of the Mitchell operating agreement. He could probably give a more efficient answer.
Is it Mr. Kearns or Mr., I was under maybe the false impression that Mr., well, let me find the document here, Mr. Overstreet.
If there's a better witness, I'd be more than happy to withdraw the question.
I think the
Oh, I
third-
see. Mr. Vaughn is everybody except the Mitchell operating agreement. Okay. It's your,
I'll wait for Mr. Kearns. Mr. Madison, thank you very much.
Thank you, sir.
before we move on to the other witnesses, I don't know, Mr. Kearns is here. I think that we'll go ahead and mark Mr. Kearns in the category of we'll have questions for him. So, I'm trying to think. AGKUC, Mr. Childers, Mr. Miller, do you have any questions?
Thank you, Mr. Chairman. Yes, just a couple. Good morning, Mr. Madison. How are you?
Good, thank you. Good morning.
Great. Yeah, just briefly, I appreciate Mr. Kurtz's questions and your responses. On the question that came up a couple times, a couple different ways about, possible future capital expenses, that may come up over and above the case 2 CCR only that this commission approved in its order in the CPCN docket. And you responded that if something theoretically were exclusively to the benefit of Wheeling customers, that would be Wheeling's responsibility. But, in the event there might be a benefit to KPC customers, the company, KPC, would need this commission's approval of those costs. Is that right? Over and above what has already been approved in the CPCN order?
I object. I don't believe that was his testimony.
I apologize if I misstated. I can either rephrase or Mr. Madison, you can clarify.
Mr. Miller, why don't you ask the question, and if you can, without restating the testimony in the form of a question.
So, Mr. Madison, would you agree that any capital expenses that may arise prior to 2028 that were not part of what the company outlined in its case 2 CCR only case in the CPCN docket, but that may arise, that KPC is going to need this commission's approval to recover those costs from its Kentucky customers?
And then I'll object because it's asking for a legal conclusion.
Mr. Miller, did you hear the objection?
I did. I suppose I would ask then whether Mr. Madison believes that the company would intend on bringing those expenses to the commission's attention for authorization as a business matter and as a regulatory matter.
That's such a broad question. I mean, are we talking about a $5
Well,
widget or?
And I appreciate, I don't know if that's the basis for an objection, Mr. Overstreet. If Mr. Madison thinks that it's too remote to be able to answer, I think that's his ability to say so in his response.
Okay, y'all ready for me?
Yeah.
Well, I do believe it's a very broad question, and you use the word any expenditure, so we're not going to bring, for example, I'll use this. Today we sit here and it is, the 5th of October in 2021. We're going to be out of the Mitchell plant December the 31st of 2028. I don't know that I totally agree with Mr. Kurt's analogy about the vehicle. I've got a Suburban that's 12 years old. My wife's got a Volvo that's 13 years old. And we've made capital expenditures, if you will, and they've continued to run very well. However, if tomorrow there's a boiler tube leak and it needs to be repaired, and we do our due diligence, we check on that boiler tube leak, and we need to make sure that the plant continues to provide reliable, safe electricity for our customers, then we do that and we fix the boiler tube leak, and then those costs are allocated to Wheeling and to Kentucky for the benefit of both customers. But to speculate on any and all capital expenditures, I can't do that. It's too broad.
Sure thing. Thank you, Mr. Madison. Thank you, everybody. I absolutely appreciate that, and I didn't mean to suggest any $5 expense. I suppose I meant to harken back to what I thought you told Mr. Kurtz, was that the commission would have the ability to review major or significant, and I don't have a precise dollar figure on those, but substantial additional capital expenses other than what was approved in the CCR case. And so I suppose we can leave it at that. But I guess I'll ask, maybe with the major or significant qualifier, rephrase it, and if there are major, capital expenses that arise, that are going to and this is assuming, put that aside. if they arise that, you know, require an investment, that's going to benefit, you know, over the life of the plant, if the plant's going to operate past 2028, primarily Wheeling Power customers, would Kentucky Power bring those major investments that may occur in the next 7 years to this commission's attention so that it can review and decide how much the cost should be approved to be recovered from Kentucky Power customers?
No, I pose
Well-
the same objection to the extent the witness can answer. He's free to do so, but
I'll sustain the objection. Mr. Miller, can you, I guess my request is with a bit more specificity, if you don't mind. And well, I'll leave it at that.
Yeah, maybe I should just make it, not to interrupt you, Mr. Chairman, I'll just make it short and sweet, which is not my forte. Will Kentucky Power seek approval from this commission of any major capital expenses that may occur at Mitchell over the next 7 years that were not contemplated in the CPCN order?
same objection.
Here-
He's asking for.
And I'm not trying to trick anybody, it seems fairly straightforward to me, but
Mr. Miller,
I call
I'm giving you an opportunity to respond to Mr. Overstreet's objection.
I'm not sure if the objection at this point is that it's calling for a legal conclusion or that it's asking about minor expenses. But my question is just if there are major capital expenses that may come up that have not already been approved by this commission, will Kentucky Power bring those to this commission's attention for approval and cost recovery?
And that, Your Honor, requires an application of KRS 278-0201 to determine what sorts of expenses are required that require a certificate of public convenience and necessity.
Yeah, and I appreciate the objection, Mr. Overstreet. I think there may be a distinction between what I take Mr. Miller is asking is, will they bring it to the commission? I don't know that he's necessarily speaking, as I understand it, is he's coming to ask about the costs, not necessarily whether the certificate of, or whether the public convenience and necessity demands the facilities. Is that?
Thank you, Mr. Chairman. Yes, that's right.
So it's an informational type.
The distinction was not made in the question, I guess, is the reason I'm going to overrule the objection. I don't know that he's asking about a CPCN. I don't take the question as meaning, will Kentucky Power seek a CPCN for all major investments? I think the question was, will they bring those major investments to the commission's attention, was what the last question was, which is why I'm going to overrule the objection. And again, to the point that Mr. Madison can actually answer the question 7 years into the future.
So is it my time?
It's yours again, Mr. Madison.
Okay, thank you, Mr. Chairman. I want to answer it two ways. One, it's very, very broad. I can't speculate, but I will bring you to page 10 of my testimony, starting with line 22. Maybe this will be helpful. I'm just going to read it. It says, because an owner not paying for ELG is inherently not participating in the option to operate the plant after 2028, Kentucky Power could potentially avoid some expenditures needed to maintain the operating capability of the plant after 2028. Logically, the cost of any non-ELG capital investments that are made and become operational before 2028 and continue to be used after 2028 would need to be fairly apportioned between the companies. And I think at the heart of your question is, at least I'm not trying to speculate what your question is, what I think I heard you say intertwined in there is trying to ensure that Kentucky ratepayers aren't paying for anything that they will derive no benefit from. And this that I just read is a suggested piece of language to be put in a new operating agreement that I believe protects from that, if that's the essence of your question. That's my answer.
Thank you, and I appreciate that. And I, at bottom was just trying to have it be clear that this commission would have the opportunity, whether in a CPCN docket or otherwise, I'm not asking you to guarantee that, to review what those costs are and to make sure, as you just recited from your testimony, that they would be fairly apportioned between the companies so that KPC's customers are not paying for things that are not fair, just, and reasonable for them to support. And so the testimony just cited does not say that explicitly, but is it fair to say that if that arrangement were reached, and you just acknowledge that there need to be fair apportionment, would Kentucky Power present to this commission any such costs, or major costs, so that that could be reviewed and authorized?
Well, in a
And I
broad
have
sense,
the-
this commission
Yeah,
has the ability and does.
Excuse
me,
look
Mr.
into
Madison.
every expense. I'm sorry, someone trying to talk?
Yeah, it's not your time. Hold on one second. Your attorney has an objection.
Then when
I'm
the
sorry, I
use of
didn't
the
hear you.
word authorized, that does invoke the CPCN statute.
I-
I-
And thank you, Mr. Overstreet. Maybe I'll say, or approved for cost recovery.
Well, costs costs are incurred every day, and then when the company files a rate case, the rates, in determining what's a fair, just, and reasonable rate, the commission examines those costs.
Right.
But
I didn't mean to insist that it would necessarily be prospective and not retrospective in a rate case. And perhaps we can move on, because I appreciated Mr. Madison's response, and the commission in the future will certainly exercise its prerogative to review the associated costs, I think. I just had been intending to, clarify, I believe what I think Mr. Madison is saying, and I thought he had said, which is that, major unexpected costs that may arise in the future will be before this commission at some point, so that Kentucky ratepayers can be fairly protected. But we can move on, and I just have one more question, and it's out of the same fundamental concern. And this relates, Mr. Madison, to possibilities that on page 11, surrounding text of your testimony, there are different possibilities for the disposition of Mitchell that you flagged, and it could be a sale to Wheeling of Kentucky Power's share, it could be a sale to a third party. So I want to ask you, instead of capital investments at the plant, I want to ask you if there's any new contract that KPC enters into for purchase of Mitchell's power in the future. Whatever term KPC's entitlement to the power may run out, whether it's 2028 as under the current, I'm sorry, just however it may run out. If there's an arrangement that AEP, Wheeling, and Kentucky Power may arrive at, would a power purchase agreement for capacity and power from the Mitchell plant be subject to review by this commission.
Your Honor, I'm going to object again. Now he's
Yeah,
asking for
sustained.
application of 278,300.
I think I think what I'm getting at is, for my purposes, pretty clear under the law. So I think folks probably understand what I'm getting at, and I guess I don't think it's legally controversial. So I'll just leave it there. Thank you, Mr. Madison. Thanks, everybody, for bearing with me there, and I appreciate your time.
Ms. Grumman, do you have any questions?
No, Your Honor.
Ms. Vincel?
Yes, Chairman, just a few. Good morning, Mr. Madison.
Good morning.
If another witness, you want me to direct this question to another witness, please let me know. I wanted to,
Sure.
and I'm thinking this one may go to Mr. Kearns, but I want to start with you. And this is in your testimony when you discussed that the only impact of the strategic review on Kentucky Power was an increase in generation employee transfers. And what my question is getting to an impact on the ability to provide reliable service. Do you know the percentage of employees who requested transfers?
I don't know the percentage, and I would refer to Mr. Kearns. He'll have those numbers of percentages. But and I'm sure it's pretty clear what happens, and he can definitely elaborate. But those jobs and those power plants are very skilled positions that could be switch operators that are in the plant that take years of training to become a journeyman, and just finding those out on the street, they're not readily available. And so to ensure that we did not have a problem, that's why that temporary suspension of transfers and movement of employees was put in place. But Mr. Kearns is much better apt at being able to tell you the details.
Thank you so much. If the Mitchell operating agreement was modified or amended, can you tell us what regulatory approval would be required?
It's got to come before this commission body to approve any amendments or changes that we make in the current existing operating agreement. So we would have to file it with this commission.
And would you also file it with the West Virginia Commission?
I believe we would.
And with FERC?
That's correct.
When Mr. Kurtz was asking you about expenses that might be incurred prior to 2028, you talked about the benefit to Kentucky Power customers, and that would be a case-by-case decision about how projects were allocated. When you say benefit, can you define what you're thinking of, what a benefit is that would be the benchmark?
Well, I don't know if this would be the benchmark, but I can just give an example. And I think I used like a boiler tube leak earlier with Mr. Miller, that if that occurs in 6 months from now, a year from now, that's got to be repaired so that both customers in Kentucky, West Virginia, that currently gain benefit from the output of that plant can continue to do so. And that's in our portfolio where our generation is today. So we've got to have that plant up and running. That would be an example. And then I think I went further to say that if it's known that there is an expense that only benefits a Wheeling customer and there's no benefit for a Kentucky customer, then we wouldn't want a Kentucky customer to pay for that expenditure. That's the best that I can give is just an illustration. I don't know about a benchmark or a threshold.
And I have a question about a potential conflict in depreciation rates for the Mitchell plant. Would you agree that the authorized depreciation rates for the Mitchell plant are determined by this commission, but also by the West Virginia Commission?
Yes.
And if there was a difference between the two commissions in the depreciation rates, how would they be allocated? For example, a load share ratio?
I would ask that getting into the technical ramifications of that, and I'm not sure, but I believe that witness bond might be able to talk about, rates, how they would be applied and those type things.
Okay, thank you, Mr. Madison. Staff has no further questions.
Thank you.
Vice Chair, do you have any questions?
I do have some questions, thank you. Good morning, Mr. Madison.
Good morning.
I'm trying to figure out, just as a factual matter, how things are organized with respect to the Mitchell plant under the operating agreement. And I don't want to ask you for legal conclusions, I'm just asking for how on a day-to-day basis things work. I read the operating agreement to say that Kentucky Power is actually the operator of the Mitchell plant. Am I understanding that correctly?
That is correct.
Okay, so are all of the, say, air permits, water permits, everything in Kentucky Power's name?
They're in Mitchell's name.
Okay, so Mitchell itself as an entity applies for the permits. They're not in the name of the operator?
They're applied for through the operator, Kentucky Power and Wheeling, on behalf of the Mitchell plant.
Okay, and this, I know that Mr. Spitznagel is the environmental compliance person, and I can ask him too.
Yes.
As far as, say, the NPDES application for ELG, is Kentucky Power on that permit currently?
I would refer you to Mr. Spitznagel.
Okay. I know in your testimony, you for this hearing, your pre-filed testimony, you discussed that that Kentucky Power and Wheeling are exploring options for changes to the operating agreement in light of the differing decisions on ELG by the two commissions. Have you made any progress on what you might propose, or are you awaiting the outcome of the hearings?
It's the latter. We're waiting. However, we have been working together. I've been consulted, and our teams have, with various options, but without having a known outcome, it's very difficult to get definitive on what that operating agreement would look like. That's why in my testimony we couch this as provisions that could be considered. But we're definitely in the talks of playing the what-if game, if you will.
Okay, what unknowns are there that are preventing moving forward right now, just so I understand the full universe of the unknowns?
Well, I think I would start first by saying, the knowns are, we know what this commission ruled on in our case 2, CCR only, and we're awaiting an October the 13th ruling from the West Virginia Public Service Commission. If they're going to say CCR only, or they're going to say both CCR and ELG. And if they say the latter, CCR, ELG, move forward, then that necessitates changes in the operating agreement definitively.
Okay, so, and I want to make sure I'm fairly restating you. The unknown right now is in West Virginia's hands, is that right?
I would couch that as being correct, because we have these conflicting current, state commission orders, and that's why that Wheeling has asked for clarity with the West Virginia Public Service Commission.
Okay. And since I know you're on the Kentucky Power side, you may not know this. I was reviewing some of the hearing transcripts in the West Virginia matter, and I understood there to be a possibility that West Virginia could approve ELG, but only on one unit. Is that your understanding as well?
I had not read those excerpts in detail. That may be. I'm not sure.
Okay, well then I won't belabor that issue. If you get the decision by October 13th and West Virginia does approve ELG to move forward at the sole expense of West Virginia taxpayer or ratepayers, how do you believe you can quickly and reasonably get the amendments made to the operating agreement and filed with FERC so that ELG can proceed?
Yes, that's our intention. Not only with FERC, but with our state commissions as well. And that's our hope today through these hearings, is to get clarity of where this commission is, because time is definitely of the essence.
Okay, and speaking of that, and I know that this was a document filed by the attorneys, and this may need to be directed to the attorneys, but are you familiar with the application for declaratory order that was filed?
Yes, I am.
Okay. There's a statement on page 2, and I know it's probably not in front of you, but it says that a lack of clarity from this commission and the Public Service Commission of West Virginia that Wheeling's completion of ELG compliance work at no cost to Kentucky customers may go forward pursuant to the ELG rule schedule puts in jeopardy Mitchell's ability to operate after June 2023. I don't understand the relevance of June 2023. Is that something you can explain, or will that be someone else?
I can say that at a high level, but definitely Gary Spitznagel is the expert on EPA rules, but it has to do with a requirement that EPA has, that they can get a definitive answer and be told what the intentions are at Mitchell. And if there's not clarity around that by date specific, then the plant's got to close much earlier than originally anticipated. But Mr. Spitznagel can give you those details.
Okay, well then I will dive into that statement with Mr. Spitznagel. I think that's all the questions I've got. Thank you.
Thank you.
Commissioner Butler, do you have any questions?
Not at this time.
Good morning, Mr. Madison.
Good morning.
I have a few questions for you. Is it your understanding that Wheeling Power has already received certificates of public convenience and necessity for both CCR and ELG?
That's what I understand.
Okay.
Mr. Chair.
And this current proceeding that's back in, I guess it's the same proceeding, the latter part of the proceeding in front of the West Virginia Commission with Wheeling is related to maybe the equivalent of what we have here in Kentucky, their environmental compliance plan, the cost recovery portion of their environmental compliance. Is that your understanding?
At a high level, yes, it is.
Okay, and I don't mean to say they're identical, but at least comparable. So Wheeling has already received, as I understand it, CPCNs for CCR and ELG.
Your Honor, just so I'm clear, are you speaking from the West Virginia Commission?
From the West Virginia Commission, certainly. Wheeling has already received CPCNs for CCR and ELG from the West Virginia Commission. And I assume the law is very similar. It's similar in most states, that their commission found that they satisfied the CPCN standard and that the public convenience and necessity demanded those improvements. Here, this commission found that the public convenience and necessity only demanded compliance with the CCR rule, and the order will speak for itself, but I think the conclusion of the commission was that the company failed to meet its burden of proof that a CPCN was permissible, whatever the term may be, for ELG compliance. Is that your memory?
Yes, it is, from this commission.
Okay. And so at this point, forgetting the cost recovery portion, at this point, does Kentucky Power have a position as to whether or not Wheeling Power can move forward with building or complying with CCR and ELG the same as if this commission had approved the compliance plan, the proposed compliance plan for Kentucky Power that include CCR and ELG?
That is my broad understanding that yes, that effectively, you know, we had case 1, case 2 before this commission. As you just stated, this commission chose case 2, which is CCR only, and I believe in our filing it effectively said that Kentucky Power would be out of Mitchell at the end of 2028. So yes, with your assessment, I agree.
Well, and that's, I think, an important distinction there, Mr. Madison, is I don't know that this commission set a retirement date for Mitchell. I don't know that this commission has ever set a retirement date for electric generating unit. But that, at least as I understood the application in front of us, was that it was the company's testimony that for ELG, that you either have to be compliant by a certain date, and that may be that June 30th, 2023. If you choose to become ELG compliant, you have to be compliant by a date certain. If your plan is to not be compliant, then you may operate the plant until December 31st, 2028. Is that your understanding?
That is correct.
And so I just want to sort of reiterate that it's your position, or I asked if the company had a position, and you stated, I think, correct me if I'm wrong, that the company's position is that Wheeling can move forward with CCR and ELG compliance for the Mitchell plant, which will allow it to continue past that December 31st, 2028 date, correct?
That's correct.
And now what Kentucky Power, what your all's discussion is related to is effectively using that December 31, 2028 date as the end of when Kentucky Power proposes to be involved with the Mitchell plan. Is that correct?
That's correct. And subject to check, Commission Chair, I believe we had words in our filing under case 2 that said that case 2, that the plant must retire at the end of 2028 and replacement capacity obtained thereafter.
Okay, and that's
so the decision.
Please proceed.
I'm sorry, go ahead. But I was going to say, and so in our mind, when the decision was made from this commission, that's what we assumed was taking place.
Okay. So one of the things that you mentioned, I think it's page 11 of your testimony, and I don't want to be unfair, I'll give you an opportunity to go to it. Page 11, line 14 of your testimony. Let me know when you're there.
I'm there.
I have the written quote here as something about the fair apportionment of future costs of retirement and removal of the plant. Do you see that?
Yes, I do.
Okay. What is your understanding of the fair apportionment of future costs of retirement and removal of Mitchell? What was that fair apportionment, or are you aware of any fair apportionment when Kentucky Power purchased a 50% undivided interest in Mitchell from an AEP affiliate?
Well, there was a cost involved when we purchased the 50% undivided interest from Ohio Power. The decision was made and approved by this commission October the 7th of 2013. And so that cost of that asset has been being depreciated over time, and it was set up through 2040. So if we're out of that at a specified time of December 31st, 2028, then what that statement means is we would have to look at what's the fair portion cost, that's the future cost and retirement and removal of the plant, or words that we would change in that operating agreement. How do we unwind and Kentucky Power get out of that at that time in the future?
Right, but if the plant's going to continue to operate past December 31st, 2028, you all purchased Mitchell at the net book value, correct?
Correct. 50%.
Okay. So why? If Mitchell's not going to be retired on December 31st, 2028, somebody's going to continue to operate it, why should there be a fair apportionment of retirement and removal costs?
Well, I'm not sure about removal of the plant and try to future speculate, if the plant would actually, if there's 2 units, if one would remain, one be removed. That's just a statement in there that is an opportunity to change the operating agreement. But we own 50% of that asset. So if it's not fully depreciated, or if it has a value at the time, or it doesn't have a value at the time, that's really what that's saying.
Right, but that's not, this portion, as I understood it, is not related to should Mitchell continue to be owned 50% undivided interest between Wheeling and Kentucky Power. This section, starting on line 7, is regarding the purchase price should Kentucky Power sell Mitchell to Wheeling. So my question is not what happens if you're still part of the agreement and you all stop in 2028. My question is, if this is sold, which is what I understand your testimony to be, when you're discussing here starting on line 7 of page 11, going on down to 14, that you're discussing what the purchase price would be if Kentucky Power sells Mitchell. And so my question is, why should the purchase price include a fair apportionment of retirement and removal, the cost of retirement and removal of the plant?
Well, it may not require removal of the plant, but there's got to be some cost assessment because we still own 50% of that plant. So at some point in time in the future, if you're out of that investment early, there could be value there. There may not be value. And that's what that statement in a broad sense is trying to get at without being specific.
But going back, you all purchased your half interest in Mitchell at the net book value. Just net book value. No net book value with a fair apportionment of retirement costs. Net book value. Now, net book value may have included accumulated depreciation over time for terminal net salvage. This is not part of the question. I doubt it, since that was an issue in recent cases to add terminal net salvage, I think, to the depreciation rates for plants. But it can include those things. I'm asking, are you envisioning something different in this line when selling Mitchell than net book value?
And I would ask, someone like maybe it could be, an Alex Vaughn that has more of a regulatory accounting perspective on this. I just know that there could be value for Kentucky. There may not be value for Kentucky at the time that we exit that plant. And if so, there's got to be a way to allocate that at that time. And that's what this is as a suggestion to the operating agreement. And, Mr. Kurtz and I talked about the unwinding period. That's when this would occur. And if there's value, then it would be assessed at that time. If there's not, then that would be dealt with at that time. And if there's undepreciated assets, that would be dealt with at that time.
So your understanding, and we discussed this earlier, that Mitchell was sold to Kentucky Power for the net book value. Is that your understanding?
I believe it was $536 million from Ohio Power in October the 7th, 2013 is when it was approved.
Yeah, I think that's in the neighborhood, $536 million, with a most favored nation clause that if West Virginia set a different price, it would be the West Virginia price. So in your opinion, is net book value an ordinarily a fair characterization of the remaining value of an asset when something's being sold?
That's normally a fair characterization.
Is part of the consideration that you're having with these initial discussions with Wheeling Power, is Wheeling Power becoming the operator of the Mitchell Power Plant?
Yes, it is.
Okay. And the reason I ask is I think in one of your responses, you sort of couched to Mr. Kurtz, you couched it with, if Wheeling is going to be the operator, and then you can continue with your answer. And I'm not asking for a legal opinion here. Does that fix a lot of the problems as you see it if West Virginia moves forward with allowing Wheeling to recover the cost solely for ELG and Wheeling Power moves forward with ELG and CCR compliance? Does that making them the operator fix quite a few of the problems that are currently inherent in the operating agreement?
I think it helps. It doesn't, fix everything, but it's definitely helpful when we have these two conflicting, decisions with CCR before this commission only, and if on October the 13th that the West Virginia Commission decides to go CCR and ELG, then they would need to be the operator because in 2028 we're out, and then they'll continue on with the plant for another 12 years. So it will be helpful to change that operating to them being the operator if that's such that the West Virginia Commission, as I described, rules.
Okay. So Kentucky Power is out of the Rockport UPA December of next year, correct?
December 7th, 2022, that's correct.
December 7th. And then, at least at this point, it's Kentucky Power's plan to be out of the, and I'm going to say out of, because that's not a technical term, out of the Kentucky Power Mitchell plant at the end of 2028. Is that correct?
That's correct.
And then Kentucky Power, and this is a guess from memory, is Kentucky Power's current estimated retirement date for Big Sandy 2032?
Subject to check, I believe that's correct.
Big Sandy 1 is a converted gas-fired power plant, correct?
Right, it was coal that's converted to gas-fired today.
Okay. And so it still operates on a boiler system, is that your understanding?
Yes.
Those boilers are pretty expensive. Is that right?
Well, I mean, in my opinion, when you're talking about a generating facility, there pretty substantial costs involved.
Yeah. No, there's nothing is necessarily cheap when you're talking about something on that scale, but a replacement of the boiler is, at least my understanding, is a significant capital expense. Is that your impression as well?
If you were to replace the entire boiler and utilize another technology, it would be expensive for sure.
Yeah, and if you had a boiler break, right, that would require the boiler itself to be replaced. That necessarily wouldn't be cheap. Is that fair?
Well, I would ask that maybe Tim Kearns would be the one to answer that, since I consider him kind of the boots on the ground and operating the facilities. I mean, you've had boiler tube leaks, but I've never known, and I may be wrong here, I've never known in my 30-something year career that there's been an entire boiler that has been replaced out of a generation facility.
Well, the reason I ask is it's a low-hanging fruit, big capital expense, costly part of these power plants, right? And I ask just to understand and appreciate the company's perspective on something. The current anticipated retirement date for Big Sandy 1, and I think you said subject to check, but it always makes me feel, maybe it's like a misery loves company situation. It always makes me feel better if I'm wrong that somebody else is wrong too. But I think it's slated for 2032 retirement as well. If something that's, the cost of replacing breaks 3 5, 6 months prior to the estimated retirement date of a major generating facility, it would just seem like common sense for me that if you're about to retire it anyways, and the replacement cost is in the tens of millions of dollars, that it may just make sense to go ahead and retire it 3 months early instead of, some arbitrary date 3 months out into the future. Is my sort of common sense perspective on things, sort of how you think about items like that?
Yeah, in my mind, from a common sense, from a business perspective, if you've got a generating facility that is going to retire in 6 months, and there's a catastrophic failure, and it costs $20 million to repair it, you wouldn't spend that money because, number one, if it's a $20 million repair job, you're not going to get it fixed in 2 days, and that just would not make sense to do that. So you would try, this is just me talking, you would try to go out to the market to see if there was capacity available if the load required it so that you could get through, or you would start with, if you're retiring in 6 months, you've already figured out where your next kilowatt hour is going to come from to replace that capacity if you could accelerate that contract. That's just my common sense approach.
Yeah, I think that's fair enough. Do you know, at least generally, the reason Kentucky Power estimates that the current retirement date, at a very high level, the current retirement date for the Big Sandy 1 unit is 2032? Is that because it's anticipated that the cost of keeping it open past that would exceed the cost of replacement generation?
At a high level, that would probably factor into the equation.
Okay. So, Mr. Madison, my understanding, and this is informed by the the affidavit at the end of the petition for declaratory order filed by the company in this case, that you're aware of the petition for declaratory order because you were the affiant that provided the factual basis for the application. Is that correct?
That's correct.
Okay. And from that perspective, I appreciate the interest and clarity and appreciate at least the assertions that were made in the application. But was that application done at your directive?
Yes, we worked as a team with legal counsel to create that affidavit and that order because time is of the essence. We've got some very, very big decisions that we're trying to make. When you consider, next week is October the 13th, there's EPA deadlines that we've got to get clarity, and it puts the completion of, ELG cost, as we talked about earlier, at no cost to the Kentucky, customers, and we don't want to put in jeopardy the issue we mentioned earlier. And again, Mr. Spitznagel can give the specifics, but there is a date certain around June of 2023 that if we don't file with the EPA currently by October the 13th, we've got to shut the plant down. So we've got to get clarity.
So you indicated earlier what your sort of summary observation of what the request was in that application. But specifically, and I've got it in front of me, and the document will speak for itself, but specifically the request on page 26 of the application is that Kentucky Power Company respectfully requests the commission to issue an order on or before October 8th, 2021, declaring that Wheeling Power Company is not required to seek and obtain from this commission a certificate of public convenience and necessity to construct, quote, any plant, equipment, property, or facility, end quote, at the Mitchell Generating Station required to comply with the ELG rule. From your perspective, what's the impetus for the need to request the for the application for a declaratory order?
maybe I have this in a different opinion, but I thought that it was that this commission is not having Wheeling Power seek from this commission a CPCN so that they can comply with the ELG, EPA rule.
Yeah, I'm unaware of any order I'm unaware of any order from the commission that would indicate that Wheeling Power must receive a CPCN for anything from this commission. But what I'm asking is, under what concern does the company have that it felt it needed clarification from this commission whether or not Wheeling needed a CPCN to comply with the ELG rule? Is there something that we said or that we did or that was in an order? Or is it something that somebody said on the news? Is it a letter you got in the mail? I'm just kind of curious, what is it, the impetus for the concern that you all felt the need to seek the application for a declaratory order?
Well, I'll give you what I think it is, and I would ask for Mr. Overstreet to give some legal guidance here as well. But if I'm not mistaken, in our formal hearing, I thought this commission said as a question, it wasn't definitive, but as a question was that, does this commission need to grant Wheeling a CPCN for them to construct ELG compliance on the Mitchell plant? So with that, we issued this order.
Okay. I have a new line of questioning, Mr. Overstreet, if you'd like to. I'm not asking you to testify, I promise you. But that satisfies my questions, unless you have anything on that issue.
No, I would just point the commission to page 8 of its September 15 order, where it identifies among the issues the need for a CPCN even if West Virginia PSC approves Wheeling's petition.
And I take Mr. Madison's response is that at least Mr. Madison read that as being, does Wheeling Power need a CPCN from this commission even if West Virginia approves Wheeling's petition? That sort of was read into that.
Yes, and particularly in light of the commission's, was it June 15 or July 15?
It all runs together. I don't even know when y'all are supposed to file your next rate case, so clearly all the dates are running together for me.
It's order in the CPCN case.
All right, on a different line of questioning, Mr. Madison. My understanding is that regardless of the officers of Kentucky Power, who the CEO, CFO, treasurer, that you as COO have, and I'm paraphrasing here, but this is my understanding, that you effectively have profit and loss responsibilities for Kentucky Power. Is that correct?
Yes, Kentucky Power is a standalone entity, and that is correct.
Say that again, I'm sorry.
Kentucky Power is a standalone entity. In other words, Kentucky Power is a utility, and there's profit loss responsibilities, yes.
Okay, and so do you do your own, capital plan and investment plan, and then seek dollars from that plan on an annual, biannual, triannual process from AEP? Seek
Yes,
investment from AEP?
Yes, we do. We put together our capital plans, our O&M, how we intend to operate the company. We begin that process, and then we lay those plans out. And as you mentioned, the CFO organization looks at all of those plans across AEP, and then it gets approval.
Okay, and so the CFO of AEP is also the CFO of Kentucky Power, is that correct?
Yes.
And who is that?
Julie Sloat.
Okay, and she's fairly new in that position, is that correct? It used to be Mr., I think, Tierney?
Yeah, she's fairly new in that position, but she's been in the financial group for quite a period of time as the treasurer, the controller. Then she was president of Ohio Power, and then recently she took Tierney's place at the
Okay.
beginning of the year.
Okay, and so, and how do you, I've seen it written, is it SLOAT, is that correct?
SLOAT, yes.
So she's the CFO of Kentucky Power, the CFO of AEP. Is she involved in the Kentucky Power plan prior to it being, like, does she as CFO of Kentucky Power work with you as COO of Kentucky Power, work and create Kentucky Power's plan, or is that done just by you and your team there in Ashland primarily?
That's done by myself and my team. It's a bottoms-up plan. In other words, we talk with distribution, we talk with all our business units, customer service, everyone, and create the plan ourselves.
Okay, so you all have that plan. At a very high level, can you walk me through the timeline that you all come up with those annual plans? Does the process start the year before, months out, and then that you all start talking to your distribution, transmission, generation groups? Can you walk me through how each iteration of that plan, beginning to end, sort of comes about?
Sure, I would call it a living document, if you will. And what I mean by that is it never stops because there's needs always in this business. And as you can imagine, with any business, there's never enough money to do everything you want to do. So that's why we have a 5-year plan in reliability. We have things that we want to do from a community perspective, customers, you name everything that we do in that large bucket, and then it gets proportioned out as to how are we going to do this, where are we going to get the money. There's not a limitless supply, and so we'll start that in sometimes the spring. For example, this year we begin those discussions, and then through the summer, and then we put our plan together, and in August that's when we had what is called an investment review committee meeting. And that's where we had the CFO and others with our parent company, and we laid our plan out. It was approved, and same sequence happens on an annual basis.
All right, so when does that investment review committee meet?
This happened in August of this year, 1st of August.
All right, and if you all start that in spring, when you say spring, you mean March, April, May, April, May? When are you thinking that spring or summer?
April, May, June,
Okay.
July, we're working constantly on the plan.
Okay, and so so you work on it, you get it going bottoms up, late summer going into August, effectively, you then send it along and have conversations with the investment review committee, and that's at the AEP level, correct?
That's correct.
And that's when you get an initial indication of what the capital, how much capital will be available to you in the subsequent calendar year. Is that right?
Calendar year. It would begin January 1st, 2022 for this session, and as it did for January of 2021.
Okay. And you all have had that meeting and have effectively been told what your allocation of capital will be, at least as the initial plan, to your point, living, breathing document. But as a snapshot of, we expect to be able to provide you X amount of capital over the next year for your investment needs to provide service to your customers.
Correct.
Okay. And then when you get the money, I assume you don't get a check on January 1. How is that amount allocated? Is it monthly, quarterly? Is it set based off of at what point during the year you intend to make investments? Because I can only assume that they don't want you holding on to cash for the first 6 months if you won't need it to the second half, because, even in a 6-month time period, there's a time value of money component there.
Well, it depends on what the expenditure is. You have daily expenses, you have things that have a quick turnaround, and then if you have certain projects that you're working on, you try to allocate it on a monthly basis, or you may load it because it's all going to occur in June or July. So it's spread out through the year.
So is it based off of what your anticipated cash needs are on any given day, week, and month?
No.
Okay. So can you, because I assume, that's effectively what we're talking about is cash needs, right? Because you're capitalizing these costs. That's great, but that's for book purposes. You actually have to buy the steel, you have to buy the wood, you have to buy the wires. And I assume that's where you're depending on AEP to get their investment monies to be able to invest in your system. So walk me through exactly what it is that they're giving you, and when and what it's based on.
Well, it's based on what our programs are for the applicable year. And I'll just give you an example, the best way I know how to do it. If we have a circuit rebuild going down Winchester Avenue in downtown Ashland, Kentucky, and that's going to cost $987,000. So that's put in a pro forma. The folks that work at Kentucky Power do this work and show when that's going to drop, if you will. In other words, the completion of that job, and there has to be purchases of materials, allocated costs, etc. So that's how that project would happen. And in June, that's when it would be booked. Now, as you know, we don't get paid for that because it's a capital expenditure until we come back before this commission and we file a rate case, and then the prudency check happens.
Right, but so you make your investment, right? You make your investment, you're able to recover QIP, whatever it is on the books. It goes into service, it goes into plant and service, and you're providing that service based off that investment. Is that correct?
That's correct.
Okay. And then that's distribution. Is there any difference between how your distribution costs come from the bottom up versus your transmission and generation costs? Is there more interplay with the AEP-SC folks on the generation and transmission side than there is on the distribution?
I would call it, we have a very robust conversation and interplay with all our working groups, with transmission planning, with generation. They do the exact same thing from an RFP perspective. We sit down or we have meetings, we look at what expenditures are needed, what's planned, we do the same process.
Yeah, but I can appreciate that the majority of the distribution function for Kentucky Power is being housed in Ashland and across East Kentucky. I guess what I'm asking, we talk about a bottom-up approach, are you getting more input on need from the AEP-SC side on generation and transmission systems than you are on the distribution system? Do you depend on those transmission and generation groups at AEP more than you do for distribution for capital planning purposes?
I guess I'm not following you. We whether they work directly for me or not, we work the same. There are groups in transmission planning. We have quarterly meetings throughout the year and as needed if issues arise, so that we can speak into projects, what is going to be built, what's being constructed. We have the ability to push back on those and monitor costs. Same with generation. So I'm not following your question of whether they do it more or less than those that actually work at Kentucky Power.
Well, are you asking the purpose of my question, or are you asking, I guess I don't necessarily know what's confusing as to whether or not you depend more on the transmission and generation functions at AEP than you do the distribution functions. Are you saying you don't necessarily know which one you depend on more?
No, that's not what I'm saying. Are you asking me, do I depend on the AEP-SC services provided by generation and transmission? Is that the question? Because I depend on them. They don't work directly for Kentucky Power, as I do with distribution and other functions within Kentucky Power.
So I'm asking, my impression was always that the company is at least somewhat dependent on AEP for certain functions. We discussed that at the formal conference in this matter. And my question is, relative to the three primary functions of a vertically integrated utility, transmission, generation, and distribution, is Kentucky Power more dependent on the AEP-SC groups that work on transmission and generation than they are on the AEP-SC groups that work on distribution in terms of creating these annual capital plans
I would agree
relative
with
to
that
each other?
assessment.
I think we may have lost signal.
Can you hear us, Mr. Madison?
There he goes.
Yes, can y'all hear me?
Yeah, we can. Sorry. And my question was relative to each other, each of those three groups.
Yeah, and I agree with your assessment, what I said when you said y'all couldn't hear me. Can you hear me now?
We can.
Okay.
So if you're dependent on all three groups, are you dependent on any of those groups at AEP-SC more than the other groups?
That's where I'm confused, because I have to work with AEPSC transmission employees, transmission planning, transmission group, same with generation. And so I'm dependent on AEPSC employees for those functions
Yeah.
in budgeting.
And Mr. Madison, my
And
question
when-
is how dependent for each of those functions? And maybe as long as I don't get an objection for assuming facts not in evidence, I'm wanting to understand here, Mr. Madison, let's take the distribution function, right? That you're doing your capital planning for the next year. And that Kentucky Power employees have about 80% of the total information you need in order to come up with your distribution capital plan for the next year. And you're depending on the AEPSC folks for about 20% of your inputs, right? For transmission, that's just an illustration, just a question. For transmission, I'm curious how much of that total pie of input you need to conduct your capital plan, how much of that are you depending on the AEPSC folks versus the Kentucky Power people for transmission, distribution, and generation? And are you depending on them more for one of those functions than the others?
Well, to try to answer that question, all those employees are AEPSC, so I depend on those employees 100% to help budget and build, construct, repair all the facilities for generation and transmission.
If next year you're told that you will not be able to use any of the AEPSC employees, only Kentucky Power employees, to put together your capital plan in the spring of 2022, is there going to be one of those three functions that's easier than the others to come up with based off the expertise and workers that you have in-house at Kentucky Power?
Is this a hypothetical?
It is.
Well, hypothetically, I would have to try to figure that out, because I'm not really following where this line of questioning is going.
Okay, so I'll lay additional foundation, Mr. Madison. Kentucky Power is being proposed, there's a strategic review about the future of Kentucky Power as a portion of AEP. I'm asking for capital planning purposes, how dependent on the three primary functions that Kentucky Power that carries out in the provision of service, how dependent on each of those functions for capital planning purposes Kentucky Power is on AEPSC relative to each other.
Is this in the context of a strategic review?
it's a general question, but I think the concern I have and the question I have and the reason I'm asking the questions is at least in part informed by the fact that there is a strategic review. Yes.
Well, as I said earlier, all the functions in transmission planning, and generation are AEPSC employees, and I depend 100% on each of those groups.
Okay. And with distribution, do you depend on AEPSC at all or any significant amount when doing your distribution-related capital plan?
To a degree.
Okay. And is that, I mean, is that more than, are you depending on them for more than half of your inputs? Or is it related primarily to the things like DERs, where, you know, you all depend on AEPSC to do your net metering interconnection and things like that? Is it one-off or particular items?
It would be a small percent. If I had to put a percent on it, I would say probably 15% when it comes to distribution.
Okay, great. So this is exactly what I'm trying to ask, Mr. Madison. I appreciate it. So in terms of what's in place in at Kentucky Power, you guys have about, and these are your percentages, I just want to make sure I'm right, about 85% of the work you all need, let me take a step back, withdraw that. About 85% of the inputs and the folks working on your distribution capital plan are at Kentucky Power, and the remainder are at affiliates. But you all depend almost exclusively on those affiliates for the inputs and help on the transmission and generation function when it comes to the annual capital plan and that bottom-up approach. Is that accurate?
That's accurate.
Okay, all right. Has that changed since you got to Kentucky Power, or has that always been the case, or during your time?
It has not changed.
Okay, and this last year, it would seem that the time frame that you gave that you come up with your annual capital plan coincided with the public announcement of the strategic review. Were you at Kentucky Power and did this same process last year during the, let's just say early or mid-spring timeframe? Did you do the capital plan then?
Yes.
Okay. And so has there been any change of, let me say it this way. Was there any change between last year and this year in terms of the capital plan regarding distribution planning, distribution investment, as a result of the announced strategic review?
We've not made any changes in our operations and how we fund programs in relation to the strategic review. The strategic review and how we're operating the company are separate and apart. The strategic review is an AEP business decision, but we're tasked with continuing to run the company. And so to that degree, for example, this year, there's no change in capital in our O&M. When we have vacancies, we're continuing to fill positions. We're still communicating with our communities, making contributions. In fact, significant more contributions were made this year than in previous years. Some of that due to COVID, but we've not changed how we operate the company one iota.
Okay. So so it's my understanding that that the AEP Kentucky Transmission Company that operates in Kentucky, you're aware of that entity, correct?
Yes.
I'm sorry, are you talking about, excuse me, and just for clarification, you're talking about AEP Kentucky Transmission Company, what's colloquially known as Transco? or-
That's correct.
Okay.
The actual entity, AEP
Okay.
Kentucky Transmission Company. Yeah, AEP Kentucky Transmission Company. It's my understanding, Mr. Madison, and you may not know this, but they have about, and you know, we round to the nearest few million here often, or tens of millions here at the commission, that about $100 million in rate base and that's just from memory of the FERC Form 1. But it's my memory, and I'm going off of specifically the case that's included in this record, 2020-0062, which was a CPCN case that the company had, that at least a portion of a transmission project was going to be completed by Kentucky Power, and it was initially proposed that a small portion, maybe 10, 15, 20%, I don't know, was going to be completed by AEP Kentucky Transmission Company. Do you remember at least vaguely that case?
Was this discussed in our recent rate case? Is that when we talked about it?
I don't remember if it was discussed in the recent rate case, but it was a project in which an order went out around Christmas of last year where the commission approved a CPCN, and then the company on rehearing requested a CPCN for the portion that Kentucky Transco was previously going to build, but that Kentucky Power was going to move forward with building. Do you remember that?
Yeah, was this the Kewanee transmission? That's the name that comes to mind.
I believe it was. In terms of the process that you laid out for me on the transmission side, are you all made aware when you received that information from the AEPSC companies about the transmission investment needed in the next year? Are you all informed as to whether or not AEP Kentucky Transmission Company is going to be performing any of the investments related to those investments identified as need for Kentucky Power?
Well, let me say this. Here's how I'll answer that. Prior to our ruling from this commission on January the 13th of 2021, I remember distinctly during the rate case, you mentioned about Transco and then having investment in Kentucky and Kentucky Power doing that constructing. So we heard this commission loud and clear. That's why when we came back and we refiled the Kewanee project, we moved it out of Transco and put it into Kentucky Power. And going forward, all of our transmission projects will not be in Transco. They'll be in Kentucky Power.
Okay, so if there is, just make a rebuild is the easiest way to say it. If there's a rehabilitation or a rebuild of Kentucky Power's transmission system, the company's current anticipation is that those improvements will be exclusively Kentucky Power investments and not include AEP Kentucky Transmission Company. Is that what you're saying?
That's correct. I'll give you a real-life situation. I think on the 25th of October, we'll be coming to this commission filing for a CPCN on a project called Garrett. And that's an example that will not be in Transco, but in Kentucky Power, as will all our transmission going forward.
Okay. And is that Garrett, the one that you all have done some recent local meetings on and press releases on?
Yes, I believe, subject to check, I believe that's correct.
Okay. So I guess my last question is, Mr. Madison, how'd you make it happen? Is that a durable change, or is that at your request that AEP Kentucky Transmission Company won't be involved moving forward for facilities that are currently owned by Kentucky Power?
That's at my request.
Okay. And is it your expectation that that's a durable outcome?
Yes, if you're meaning sustainable, I mean, we've got a whole list of projects that we'll be dropping in over the next several months throughout the next several years for CPCN requests on transmission that will be on Kentucky Power's books, not on Transco's. That's a fundamental change we made.
Okay. And that's a change that predates the strategic review. Is that, do I understand your testimony correctly? It is unrelated.
That is correct.
Unrelated to the strategic review?
I'm sorry, I didn't mean to interrupt you. It has nothing to do with the strategic review. It has to do with how we're operating the company.
Okay. Those are all the questions I have for Mr. Madison at this time, Mr. Overstreet. My first question is, and we're going to take a quick recess, and then you'll have the opportunity to do redirect. We've been going out for 2 hours. My first question is Mr. Madison planning on being with us for the rest of the day, or does he have conflicts?
I do not believe I believe he will be with us for the rest of the day.
Okay, that was the first question. And the second is that you will expect to have some redirect, is that correct?
Minimal.
Okay. All right, we'll take a short recess until 11:15, and then we'll continue with Mr. Madison.
I can.
All right, we're back on the record in case number 2021-00370. Mr. Overstreet, do you have any redirect for Mr. Madison?
Just a very few questions, Your Honor.
All right, we'll
I'm
give,
sorry.
sorry, Mr. Overstreet, we'll give Mr. Madison just a minute, let him turn his phone on and his camera on. There we go. Please
I'm here.
proceed.
Can you hear me, Mr. Madison?
Yes, I can, thank you.
Okay, great, thank you. Mr. Madison, could you turn to pages 10 and 11 of your pre-filed testimony in this proceeding?
Page 11,
Pages 10 and 11.
I'm there.
And let's start with the question that starts on page 10 at line 11. The question is, what modifications to the Mitchell operating agreement should be made if Wheeling decides to pay for the investment in ELG at the Mitchell plant? Do you see that question?
Yes, I do.
And then there follow 6 bullets, and where you describe the types of provisions that could be considered, right?
Yes,
Okay. And then the second bullet on page 11 talks about a purchase price. Is that correct?
that's correct.
And could I get you just to read to yourself that bullet, and then I'd like to ask you a question?
Okay. I've read it.
Okay, thank you. Is it true that, number one, your testimony here is describing possible changes to the Mitchell operating agreement,
That is correct.
and not necessarily the price at which a particular asset, Mitchell or any other asset, might be sold?
No, just the context of the operating agreement.
And then number two, is it true that any sale price of Mitchell to Wheeling or to some other entity would depend on the specifics of that transaction, right?
I would agree with that.
And that amount would need to be negotiated, correct?
That's correct.
And to the extent required by law, it would be brought to this commission for review concerning the fairness of the price. Is that accurate?
I agree.
And that net book value may or may not be that fair price. Is that correct?
I agree. Net book value could be one of several methodologies.
Thank you. That's all I have.
All right, thank you, Mr. Madison. I'd asked for you to step down, but to the extent that you can, we'd request you stay, given you're kind of the glue that holds this hearing together. If you do need to step away for any reason, I would just ask that you just indicate to Ms. Glass that that's the case, and sort of seek leave to do so ahead of time so that we know.
Sure.
I don't know of any reason that I'll be stepping away, Commission Chair, but I'll remain off video and be available.
All right, thank you. Mr. Overstreet, before we move on to, no, you're fine to stand. You're fine to stand. Before we move on to who we know, Mr. Spitznagel, who we've identified by name in the order to appear, I do think that at this time, I know at least for myself, Mr. Kearns, I think the Vice Chair, myself, maybe even Mr. Kurtz have already indicated that we'll have questions for Mr. Kearns. Mr. Kearns, I think that Ms. Connor we'll need to speak with Ms. Connor. The same thing with Mr. Ali. And I believe, do you have any questions for Ms. Vaughn, Mr. Vaughn, Ms. Wenzel?
Just one.
Okay. So I do believe that all of the witnesses will be necessary to be called.
Okay, thank you, that's helpful.
And I want to give you that information as early as possible so that you will at least have the lunch break or this morning to think about how, in what order you would like to call them.
Thank you.
And you may call your next witness.
Okay, Your Honor, we call Gary O. Spitznagel, and Ms. Glass will present him.
Mr. Spitznagel, please turn on your video, turn on your microphone, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
It's Gary Spitznagel. I'm at 1 Riverside Plaza, Columbus, Ohio.
Okay. Ms. Glass, you may ask.
Thank you, Your Honor. Mr. Spitznagel, can you please state your position and the company that you work for?
Yes, I'm with American Electric Power Service Corporation. I'm Vice President of Environmental Services.
Thank you. And is it correct that you've been made available today by the company to answer questions related to the Mitchell Environmental Compliance Plans of Kentucky Power and Wheeling Power and other related matters as directed by the Commission's September 27, 2021 order?
Yes, it is.
Thank you. With that, Mr. Spitznagel is available.
Thank you. Mr. West, do you have any questions for Mr. Spitznagel?
Just a few. How are you doing, Mr. Spitznagel?
I'm doing well, thank you.
Some of this is probably documented in your testimony or in other filings in the 2021-0004 matter, but I thought it would be helpful maybe to just go over some of these questions generally. Can you provide the key regulatory deadlines for ELG compliance to the extent you know them?
Yes, so for ELG, the regulation requires compliance with the rule by December 31st of 2025. That is a last possible date for compliance, but the rule also is clear in several places that the expectation is that compliance will be achieved as soon as possible, but no later than that date.
Can you provide any other key dates? I think there's been some discussion of a date in the coming months where some clarity is needed as to whether the company intends to comply with the ELG.
Yes, the most imminent date right now is October 13th of this year, and that date is the last date that we can file with the state DEP in West Virginia, the filing of a NOP, which is NOP, N-O-P-P stands for Notice of Planned Participation, and that is a declaration statement that we will, instead of seeking to comply by making modifications to the power plant for ELG compliance, that instead we will announce a commitment to retire the power plant or refuel it by the end of 2028. And that commitment must be made in writing to the state DEP by October 13th.
So that's a requirement under West Virginia's delegated program, I suppose?
Yes, it's stated in the EPA's ELG rule, and the reporting requirement is handled through the state agency who has the authority to enforce the rule.
Mr. West, can I interject for a minute? I'd like to know from Mr. Spitznagel, we've had this in a couple of hearings, and maybe it's just a personal issue of mine. When you use the pronoun we, can you identify exactly who it is you're referring to?
Yes, I will.
Okay, thank you. Go ahead, Mr. West.
Moving on, can you discuss just at a broad, high level, what construction items will be required to achieve ELG compliance at Mitchell?
Yes, so ELG really is in very broad sense two different areas of modifications to the plant. The first set of modifications is to convert the bottom ash handling system to a dry system. It is currently a wet transport system with a ponded storage of the ash. And the first modification is to remove that system and install a dry handling system that would allow the ash to be immediately landfilled in a dry state. So that's the first modification. The other major modification is to treat the FGD or the SO2 scrubber wastewater discharge through a biological treatment system to clean up the constituents in that water stream before it is discharged.
Okay. Are those modifications time consuming?
They are. They take many months or years to complete.
Okay. And that leads to my final question. Can you just walk us through, at a broad level, the timeline for these construction items that will be required, and specifically kind of lay those out in reference to the end of the 2028 deadline that we've discussed?
Yes. So the first major component of the modifications that deals with the bottom ash transport system, that for the Mitchell plant, the date that we have in our compliance filings with the state are, when I say we, the companies have filed with the state DEP to be in compliance with that bottom ash transport requirement by June 30th of 2023. And the FGD wastewater treatment system would be March 31st of 2025.
So all these projects will be fully completed and realized prior to 2028?
Absolutely. As I stated before, the latest possible date the rule allows us to achieve compliance with those modifications is December 31st of 2025.
Great. Thank you.
Mr. Kurtz, any questions?
Just a few. Good morning, Mr. Spitznagel.
Good morning.
I wanted to ask you some decommissioning plant retirement questions. I assume that tearing down the stacks and the boilers would be the same process, different timing, if the plant retires in 2028 and 2040. Is that assumption correct from your perspective?
Well, that's not my area of expertise, so I can't speak to the timing for how long it takes to be mobilized to demolish the power plant.
Okay, from an environmental perspective, if the plant is retired in 2028, what decommissioning costs would there be for the wet ash pond and the landfills and all those environmental aspects versus if it goes to 2040, what would be the environmental decommissioning projects at that point?
The decommissioning projects would be the same regardless of the date when the plant would cease operation.
And what would those be from an environmental perspective?
I don't know specific costs.
No, what would the projects be from an environmental perspective once the plant is retired?
So the environmental projects we're speaking of, are you asking for if we file a NOC and continue to operate without ELG modifications?
Well, I thought you said that the environmental decommissioning would be the same either way, but if there's differences, I'd just like to know the different projects under the 28 versus the 2040 scenario, if there is a difference.
Under the 28 scenario, I would, just for clarity, make sure I understand what you're asking. For the 2028, that would be under the path that we would file a NOP and not do the ELG modifications. Is that your Is that what you're asking me
Yes.
regarding 2028?
Yes.
Okay, so if we do not file a NOP and we instead, I'm sorry, let me go back and clarify. 2028 would be if we file a NOP and we choose to not do the ELG modifications. And in that case, at the end of 2028, when we would have to cease the combustion of coal, we would initiate the closure of the ponds that are currently used to handle the wet bottom ash. So there would be excavation of those ponds, landfilling of the material, and returning those pond sites to their former state before ponds were constructed.
Okay, now what about the 2040 scenario where you do the ELG?
So if we do the ELG, we will already have closed those, the bottom ash pond system in order as part of the ELG installation project. So at the end of the operation of the plant using the ELG, we would not anymore have a CCR compliant pond that would need to be demolished and returned to background state. We would just have the balance of other equipment at the plant that would have to be demolished, but that pond closure would already have been accomplished.
Okay, thank you, Mr. Spitznagel. Those are all my questions.
Mr. Childers, Mr. Miller?
Thank you, Mr. Chairman. Good morning, Mr. Spitznagel.
Good morning.
So as to the dates about ELG's compliance, so just to be crystal clear, if KPC and Wheeling file, or I suppose if it's, you can confirm if it's just Wheeling that needs to file the notice of the NOP, which compliance path it's going to take. Why don't I just ask you that? Is it only Wheeling that needs to file? Whether the coal-fired power plant is going to retire in 2028 versus invest in the capital projects?
Actually, the entity that would be filing or making that filing would be Kentucky Power Company as the operator of the facility.
I see. Thank you for that clarification. That's with the West Virginia DEP.
That is correct.
And so just to be clear, if Kentucky Power were to file on the 13th that it intends to, or that Mitchell will be retired at the end of 2028, would that remove any cloud of uncertainty as to whether, at least as far as ELG's law is concerned, the plant can continue to operate as a coal-fired power plant until 2028, end of 2028?
Yes, that filing would be a commitment to move forward with the CCR components of compliance and forego the ELG investments and instead plan for retirement at the end of 2028.
Okay, thank you. And so if KPC were to do that, there wouldn't be a concern as to whether the plant could continue to operate coal-fired past 2023 or 2025?
That is correct.
So, okay, thank you. I want to ask you about, if you can speak to it, KPC's application for declaratory relief. Are you familiar with that application filed last week in this docket?
I am not familiar with the application. No.
Oh, okay.
I know it's filed, but I don't know any details.
You didn't advise in connection with it?
Regarding the environmental obligations, I provided information.
Okay, so just those ELG compliance details and not the PSC approvals, is that?
That is correct, yes.
Okay, okay, very well. Then I don't have any further questions. Thank you, Mr. Spitznagel. Appreciate your time.
Ms. Grunman, do you have any questions? Oh, I apologize.
Very briefly, I just want to make sure I run through the dates and that I understand them. So, good morning, Mr. Spitznagel. How are you?
Good morning, I'm well.
Am I correct that as it relates to, I think you denoted two main projects in terms of the ELG that had sort of, was it 2023 and 2025 completion dates?
That is correct, yes.
And so the 2023 is the sort of transition from a wet ash to a dry ash handling system?
Yes, the June 30th of 2023 is for the dry ash conversion.
And what is the, for lack of a better phrase, what is the break ground date for that?
I don't know the project schedule. It would have to commence pretty quickly, but I don't know what that date is.
So it's obviously currently not underway.
No, there's no physical work at the facility yet to complete that project.
And do you have any understanding as to the typical timeline that it takes to complete that project, sort of from start to finish?
I mean, that would be in a year and a half or more to complete that project.
So sort of a January 1 start date?
Again, I don't know what the project timeline is, but I know it's in that 18-month time frame, approximately, give or take a little, to complete that project.
The uncertainty of construction projects, correct?
Yes, there's weather and other things that drive when you're handling and closing a pond. There's a lot of factors that are out of our control.
Absolutely. And so the October 13th deadline with the West Virginia DEP, am I correct that you have sort of two options? One is to file a NOP, which would indicate that you are going to close the plant at the end of 2028. Is that correct?
Yes, that would be one option.
And then is the other option to indicate that you're going to go through with the ELG upgrades?
Yes, the October 13th date is really the opportunity, the last opportunity to file a NOP, which we just described would be the retirement commitment. If we were to choose to not file a NOP, we would just move forward with the plans as we have currently filed them, both with the US EPA under the CCR rule and with the state under the NPDES modification.
And so in the event you file a NOP on the 13th, is that decision one that is set in stone?
It is a commitment to retire, but I will say that the rule gives an opportunity to switch between one NOP and another NOP after that initial filing date of October 13th.
And what does that mean to switch from one NOP to another NOP?
Well, there are multiple paths you can take. The one that we've outlined, which would be a commitment to retire. There's also a commitment that you could make to operate the unit under a low utilization model, which would be less than 10% capacity factor. So that option is not on the table for this facility, but that is one that the rule allows for. And there's a third path known as the Voluntary Incentives Program, or VIP option, which is to commit to, instead of doing the system for the FGD wastewater treatment that we have already filed for, is to commit to a membrane system, which is an unproven technology, to achieve greater reductions in limits on the FGD wastewater stream. And that commitment, if we were to make that, would give us until the end of 2028 to make those modifications. So that is another option that we could conceivably take based on what the rule allows. But we don't believe, based on the nature of the technology that would be involved in that decision and the fact that it has never been proven at scale under the conditions that this plant operates. There's other technical concerns we have and waste production concerns and other things that we believe are problematic enough that particular path is not viable for that facility.
Let me switch topics here. And maybe you're not the right witness, you let me know. who can answer questions about what the plan is for meeting Kentucky Power's capacity obligations if the NOP is filed?
That would probably be Witness Madison.
Okay, that's fine. I just wanted to make sure. That's all the questions that I have.
Ms. Vincel, do you have any questions for Mr. Spitznagel?
Staff has no questions.
Vice Chair?
I do, thank you. Good still morning, Mr. Spitznagel, at least for a little bit longer.
Good morning.
You'll not be surprised that I'm going to dig in a little more on these dates, but as a preliminary question, who is the permit holder for the environmental permits for Mitchell?
So those would be Kentucky Power Company.
Okay, so you mentioned that for ELG compliance, that is currently covered by a requested NPDES modification, and am I right then that that NPDES permit is held by Kentucky Power?
Yes, you are correct.
Okay. You had stated that June 30th, 2023, which is now suddenly a significant date, is the deadline for compliance with the bottom ash transport water portion of the rule. Is that right?
Yes, that's what is in the draft permit that we have received from the state. We don't have the final NPDES permit yet for Mitchell Power Plant.
Okay. So that compliance date, is that one that Kentucky Power proposed be in the draft, or is that one that is in the regulation?
The regulation sets a last possible date of December 31st of 2025. However, the rule also requires to come into compliance as soon as possible. So the date of June 30th of 2023 represents an as soon as possible date based on the scope of work required to be done at the plant and how quickly we can achieve that compliance.
Okay, given the stated uncertainty as a result of the West Virginia proceedings, could that date be changed before a final permit is issued?
That would be a discussion we would have to have with the DEP. By issuing a draft permit with that date, they're essentially agreeing that that is the soonest possible date that can be achieved. There's an added complexity that the dry bottom ash conversion system is used not just for ELG compliance, but it's used in our plans to achieve CCR compliance. And our CCR compliance plan was submitted to the US EPA last November, going on a year now, as part of our request for an extension to the April 11th of 2021 date that was in the CCR rule to cease operation of that pond. So EPA would also have to be involved in a date change. And as I said, we've submitted those extension requests. We have not yet gotten an answer from EPA. And their process does not have a defined way to make a change like that before they issue an approval or not of the plans we filed.
Okay. Is Kentucky Power or whoever ends up being the permit holder prohibited from seeking additional extensions, at least up through the 2025 date?
Can you ask me that again? I'm not sure what extensions you're referring to.
Right, and I'm sorry that I know that was abundantly unclear. At least in draft permits and your modification request to US EPA, the current deadline for the bottom ash transport and CCR compliance is 6/30/23. Is Kentucky Power prohibited in asking for yet another extension up to and including the December 31st, 2025 date?
I would not say we're prohibited from doing so, but there's a number of hurdles that would have to be cleared in order to make a change. We would have to get concurrence from the DEP in West Virginia that that's acceptable and still achieves the as soon as possible requirement. We would also have EPAs have to seek their approval as well. So there's a lot of uncertainty that makes an extension very challenging to acquire at this point.
Has West Virginia DEP been relatively cooperative through this process?
Yes, from my experience, yes, they understand the urgency of this matter, and they're working on these permits. Like I said, they've issued draft permits, and they're working to finalize the permits by the end of this year. So I'd say they're moving as quickly as they can, given the workload they have and the number of permits that they're working through.
Okay. In light of the conflicting orders issued on the ELG compliance, issued by this commission and the West Virginia Commission, has any notice been given to either DEP or EPA that a permit holder change may need to be made?
We have not talked to them about a change yet. We're still waiting to get the permit finalized that we've already requested.
Okay, so you would expect to get the final permit, then ask for a change in the identity of the holder?
That is correct, yes.
Okay. Would you expect that to be difficult?
I would have to talk to my permit writing experts, but I believe that's a minor modification.
Okay.
So it shouldn't be too complicated.
And would that be true both with West Virginia DEP and US EPA?
Well, the permits are through the DEP, so the US EPA is not part of that process.
Okay. What happens if you get to June 30th, 2023 and the work's not done? You're not fully compliant with the deadline?
Well, we would have to, at worst case, we would have to cease plant operation until we achieve completion of the project. Now, if we were making steady progress towards that date, but we talked before a little bit ago about challenges to achieving dates when you're dealing with large ponds and potential bad weather and other things. If it looked at some point like that date was in peril, we would go to the DEP and explain the situation and work with them for an alternative to closing the plant or taking the plant offline for a period of time. So we would be in discussion with them, giving them, I believe the rule requires we have to give periodic updates on progress anyways. So there will be a back and forth as we make progress on this project to make sure that there's no surprises on that.
Okay, so, I apologize. I didn't mean to talk over you. So in your experience in dealing with this type of permitting, it would be a fairly remote likelihood that the plant would abruptly shut down in 2023. Is that fair?
I would say if we showed that we're making progress towards completion of the project and there were extenuating circumstances that might be delaying it, I think we would be in good standing with the DEP to work with them. If we just decided to not make progress, I think that's another story, and that could be a problem.
Okay, and under what circumstances would AEP and its subsidiaries just not make progress?
I'm not aware of it.
Ability to contemplate.
I can't think of what those circumstances would be. We've got a long track record of meeting our commitments with permitting agencies, so I can't look back and see a history where we have an example of that.
Okay, and that's what the answer was I was expecting. I wasn't trying to imply that there would be. I just couldn't personally contemplate that there would be a circumstance where you'd make no progress.
That's correct.
Okay, so that's all the questions I've got. Thank you, Mr. Spitznagel.
Commissioner Butler, any questions?
I just have one clarification. Thanks for being with us today. In the beginning, a question was asking, you spoke about modification of fuel. Are there plans to convert this plant to a different fuel type?
No plans that I'm aware of. It is spoken of in the rule, that it accommodates either a retirement of the plant or a refueling or repowering of the site. So those are options that are available to the company, but I know of no plans to pursue any change like that.
Okay, thank you.
Still good morning, Mr. Spitznagel. How long have you been doing this at AEP?
I'm sorry, doing what?
Doing environmental compliance, environmental remediation. How long have you been in this group?
Well, in my current role, it's been since July of 2019, so a little over 2 years. But I've worked in environmental areas for a long time with the company, for actually most of my career.
Okay. Is it your understanding, or are you aware of, in the past few years, that AEP subsidiaries have sold a number of power plants such as Mitchell? Is that your understanding or experience?
Yes, that is correct.
Okay. And so, in terms of your job, environmental remediation, and post-retirement, or even post closing of those power plants that were sold to non-affiliates, does AEP have any obligations after environmental obligations that you've personally dealt with after the sale of those assets?
I would say not typically. As part of the process of transferring ownership of a facility is transferring of the owners of those permits. So we would expect at the time of transfer of ownership that also subsequent to that or concurrent with it, that the permits would also transfer, and all of the responsibility for compliance with those permits would transfer at that time.
And have you been aware of whether your group at AEP there had been called on to identify post-transfer environmental costs that you're aware that Kentucky Power has paid as an offset to a purchase price, or identified as an offset to a purchase price for environmental remediation? Have you been called to do that? That, for instance, we're going to sell this power plant, but we expect it'll be retired in 10 years, and so you all need to tell us what sort of costs are going to be there for environmental remediation so that we can, take that into account when selling. Have you been called to do that in any of your positions, or aware of your group having to do that?
I personally have not, but I would imagine that if asked about future obligations required for compliance, that we've provided information as needed.
Are the coal ash ponds in this situation fairly straightforward, or are they complicated by any other entities other than Wheeling and Kentucky Power that have used or continue to use the ash ponds?
The bottom ash pond that we've been talking about for these modifications are strictly used by the power plant operations.
Okay, and is that exclusive to the bottom ash ponds? Are there any other ash ponds that have been used by any other third parties that are unaffiliated with the power plant that you're aware of that complicates the situation?
Not regarding this compliance with this rule. I believe there's another landfill at Mitchell site. I'm not very familiar with all the details of it that are used by another entity.
That's fine. Have you ever heard of Southwestern Electric Power Company?
Yes.
Okay. And have you had the occasion to work on behalf of Southwestern Electric Power Company?
Yes, I have.
Okay. And is it commonly referred to as SWEPCO?
Yes, it is.
Okay. I didn't know if just I called it SWEPCO or if other people actually did or not. It's nice to know that I have that in common with an insider. So SWEPCO is
That's what we all call it, yes.
okay, good. SWEPCO is an AEP affiliate, is that correct?
It is, yes.
Okay. And going back, ELG has been quote unquote on the books. That it's been published in the Federal Register, at least in one form or another, since 2015. Is that correct?
Yes, that is correct.
Okay. And SWEPCO, and I don't know if it's quite infamous. This is a fairly small community we have here, utility people, but SWEPCO at least was is it your understanding they were the named plaintiff in the lawsuit challenging that ELG compliance?
I don't know for sure.
Okay, well, I mean, are you aware of whether SWEPCO or any other AEP affiliate sued to challenge the initial ELG regulation following its publication in the Federal Register?
I'm not aware of any lawsuits, no.
So it's your understanding that that the ELG was published in the Federal Register in 2015, correct?
Yes,
Okay. And it's been amended since then, is that correct?
yes, it has.
Okay. So it was published, and my understanding, what I have, is November the 3rd, 2015. That's at least what regulations.gov has. November of 2015, Louisville Gas and Electric Company filed their environmental compliance plan with this commission early in 2021. The exact date is probably immaterial. March 31st, 2020, excuse me. March 31st, 2020, which included their environmental compliance plan for ELG compliance. If the plan was put in effect in 2015, and you at least have dates here that are June 30th, 2023, that you have to start handling bottom ash through a dry process instead of a wet process by June 30, 2023. Why is it that Kentucky Power didn't file do you know why it wasn't until earlier this year that Kentucky Power filed their ELG, their compliance plan to comply with ELG?
Well, because we were waiting on that finalization of the rule that was the current version that we're referring to was finalized in August of 2020. So the plans to meet the requirements of that rule were put together and finalized after that date.
When you say finalized, they were published in August of 2020?
The final rule was put in the CFR in either August or September. I can't remember the months, but of 2020.
Okay, and so when would the company have been on notice about the proposed ELG changes?
The draft rule was issued earlier in 2020.
Okay.
I don't know the month, but it was early in 2020.
And so specific to the major capital improvements necessary to comply with ELG, was there anything from your perspective that significantly differed between what the proposed rule in early 2020 indicated and what the final rule published in August indicated?
There were some changes. I'd have to look at them, talk to my team to get specifics, but there were some changes between the draft rule and the final rule.
No, I can appreciate that there were changes. Do you know if they were material to the point that they resulted in millions of dollars of changes in what the companies would have done to comply with the draft rule versus the published rule?
I can't quantify the impacts of the changes in the rule. There was uncertainty on whether or not you could have untreated blowdown with your ELG waters and other things that we didn't have clarity on until the final rule. So those types of details influenced heavily the final process we were designing and how we were going to implement ELG, especially in relation to the fact that ELG is just one rule we're dealing with here. We're dealing with two rules that were finalized in that August timeframe of last year, the CCR rule and the ELG rule. And the rules are treated in a lot of ways separately by the EPA, but for compliance purposes in our planning, we're approaching them together and developing plans that enable us to comply with both rules, because there is some overlap and looking how you would do that. So we had both rules in flux until that August time frame of last year before we could finalize plans for compliance.
So you filed, were you part of any of the other proceedings in other jurisdictions of other AEP affiliates regarding the CCR and ELG compliance?
Yes, I was.
Okay. The West Virginia Commission, the application before the West Virginia Commission was filed before this commission, correct?
Yes, I believe so.
A month or two, is that your memory?
I don't know that.
That's-
Actually, the sequence of when what was filed, I do not recall.
In what other states have you participated in the ELG compliance dockets?
I provided information, as you mentioned, to SWEPCO and guidance to SWEPCO for their jurisdictions.
Do you know when they filed their plan?
And I don't know when they found their plans. But no, I provided guidance to SWEPCO and to Indiana Michigan Power for their filings.
Do you know when Indiana and Michigan Power filed their plans with the Indiana or Michigan Commission?
I do not know. A similar time frame as far as NPDES permit modifications. Those were all filed with the different states, environmental agencies, the end of 2020 or early 2021.
It doesn't provide us much time to comply, does it?
It does not, no.
Those are all the questions I have for Mr. Spitznagel. Do you have any redirect, Ms. Glass?
Yes, Your Honor, I do, just a few. Mr. Spitznagel, the chairman was just asking you about the differences between the 2015 ELG rule and the 2020 final rule for ELG. Is it true that the October 13th, 2021 compliance date, or date by which the company would need to inform the EPA whether it will move forward with ELG, was new in the fall 2020 rule?
That is in fact true. In fact, the draft issuance of the ELG rule in early 2020 did not give any mention to this not filing date of October 13th.
Thank you. And working backwards, the vice chair was asking you questions about the NPDES permits and if the company needed a new permit or wanted to modify that permit. Would it even be possible to modify or get a new permit before that October 13th, 2021 date?
Oh, no, definitely not. We don't even have a final permit at this point, but that whole process of re-permitting takes at a minimum of 90 days to complete.
Thank you. And is it also true that the EPA has veto power over permit changes as well?
Yes, they do.
So would that also make it impractical to modify the permit or get a new permit?
It would introduce risk because the DEP would issue their permit and the EPA could look at that and either allow it or veto any decision made in a permit.
Okay. And also earlier on, the vice chair was asking you questions about the different options of filing a NOP or withdrawing that NOP. And you had mentioned that one of the paths that is possible if the NOP is withdrawn, that is, if Kentucky Power were to indicate that it would not move forward with ELG and would only perform the CCR improvements and then withdrew that NOP, that there was a possibility of what you call a VIP option. Do you remember that?
Yes, I do.
And you mentioned that that VIP option also would entail some unproven technology, and that, can you explain kind of what that unproven technology is and the risks associated with that?
Yes, that technology was intended to apply what's called a membrane system. It's basically a very, very, very high efficiency filter that would remove constituents in the wastewater down to extremely low concentrations. While membranes are proven in a lot of uses, applying it to this scale we're dealing with here at Mitchell Plant, as well as with the conditions that we would be exposing that membrane to, have never been demonstrated. So while theoretically it could work, until we see some clarity on how it performs and the challenges with keeping it operational and reliable, it's really looked at this point as experimental for this application. So there's a lot of risks committing the future operation of a power plant to something that would be considered experimental or unverified or unproven at this point. So there's technical risks that we just do not know how significant they are at this point. There's also, this process produces a very concentrated waste stream that could very likely be hazardous in its classification and problematic for the handling and disposal of it. So there's challenges with waste disposal associated with this technology. So for all those reasons, we view it as technically not viable at this date.
Thank you. And would the VIP option also require additional regulatory approvals?
Yes, we would have to go back to the DEP and seek a permit modification. The current draft NPDES permit is based on the technologies we've identified in our current permits. So there would be modifications that the DEP would have to evaluate and issue a modification to the permit. Also, potentially the need for different dates to comply with the bottom ash. So one thing I should back up and make clear, if you recall early in my testimony, I talked about the fact that there were two major components for ELG compliance. Even going down the path of the VIP to get the extra time and install an unproven technology, the bottom ash conversion to dry is not affected by the VIP process. We would still have to achieve the permit dates of the current draft permit for the dry handling system. The complexity of that is filing that NOP on October and committing to retire would lead to a stoppage of work at the facility and make it very difficult to start it up some months later and still achieve that June 30th, 2023 date. So we would more than likely have to go to the DEP and seek a date adjustment for that as well, which is problematic because the current date is as soon as possible per the spirit and requirement of the rule. So we believe there's risks with moving that date and potential EPA vetoes of any changes that could result.
And if you'll recall, at one point, Counsel for Walmart, Ms. Grunman, was asking you questions about the project schedule for the ELG projects. Is it true that the actual project schedule, if needed, could be found in the direct testimony of company witness Brian Sherrick in the CPCN case?
Yes, he included all of those details in his written testimony.
Thank you. Those are all the questions I have. Thank you.
Chairman, can I have a clarification follow-up?
Sure.
Thank you. Mr. Spitznagel, let me see if I understand this is right. If West Virginia says no to ELG, we have a wet ash pond that would have to be decommissioned at the end of 2028, correct?
If West Virginia said no to ELG, and therefore we would move down the CCR only path,
Yes.
yes, at the end of 2028, when we would cease plant operation, we would have to close the ash pond that would still have been operated up to that date.
Okay, and if, assuming that Kentucky Power has some share of the decommissioning costs, let's just assume 50%, Kentucky Power would be on the hook for 50% of the closure of the wet ash pond sometime after 2028. Would that be correct also?
I don't make decisions on how the regulatory process works and who pays for what, but the closure of the pond would take place upon retirement of the unit.
How much ballpark would the closure of the pond cost in 2028, approximately?
I do not know. I know there's numbers in witness Sherrick's testimony about cost estimates that include a breakdown of pond closure, but I don't know what those numbers are.
Okay, whose testimony?
Witness Sherrick?
Okay. Now, if West Virginia says yes to ELG and they're going to pay for all of it, that would encompass closing the wet ash pond and converting it to dry on West Virginia's paying 100% of it, correct?
Well, from a technology standpoint, let me answer that part first. Going dry to meet ELG requirements would include the closure of the current bottom ash pond.
So my question is,
The second part of your question, I don't know who would end up paying for what.
well, let's just assume West Virginia goes forward with ELG and West Virginia pays for it. Would that confer a benefit on Kentucky consumers because we would no longer be responsible for some share of closing the wet ash pond?
Yeah, I'm not the person to make statements on who benefits from the project.
If West Virginia closes the wet ash pond or converts it to dry as part of the ELG compliance, then the wet ash pond costs of retirement at some point in the future would be less because it's already converted to dry. Would that not be true?
Yes, that would be the case because we will have already closed that pond. That pond will get closed either in the near term if we go down an ELG and plus CCR path, or that pond will be closed at retirement if we go CCR only. But that pond closure is going to happen in one of those states.
Mr. Kurtz, you get your factual, have you gotten
I'm
your factual
sorry.
clarification?
Just almost. So
Can I'm sorry, Mr. Kurtz, if I can clarify. If we go, regardless of what we do, maybe I need to clarify something. Regardless of what direction we take, the CCR pond as it is today has to be closed. If we go with the CCR only option, we would still close the pond in the near term, and then we would build a CCR compliant pond that would be operated until 2028. I don't think I was super clear on that detail in answering your question a minute ago.
well, I just want to ask this one broad basic question, and then I'll stop. Is there any benefit to Kentucky in terms of ash pond closure costs if West Virginia goes forward with the ELG and pays for 100% of it?
I can't speak to who benefits from project activities. I can only speak to what is required in the project to meet compliance.
Thank you, Chairman.
Ms. Glass?
I have no questions, thank you.
Thank you very much, Mr. Spitznagel. Is there any reason Mr. Spitznagel can't be excused?
No, he can be excused.
Thank you, Mr. Spitznagel. You can have the remainder of your day.
Thank you.
Your Honor, one housekeeping matter. Ms. Connor has a hard stop at a little bit before 5. She's 2 more witnesses down. I see no reason why we wouldn't be finished with her well before that, but I just wanted to make everyone aware of that fact.
I appreciate it. Would you like to call her next after lunch?
Well, and we certainly could, unless we have some sense of how long Mr. Kearns would take.
I'd hate to limit ourselves, and it's your prerogative as to how you would like to call any of
Right,
the
we'll
employees.
confer over lunch and figure that out.
Thank you. All
Okay,
right.
thank you.
Is there anything we need to do before we take a 1-hour recess for lunch? Okay, we'll come back at, let's come back at 1:15.
Yeah, that's what I was-
now hear me for the first time. So we're back on the record in case number 2021-00370. Before the break, we released Mr. Spitznagel for the remainder of the day, and I believe that Kentucky Power has not necessarily witnesses that are identified in the order, but plans to call a number of witnesses to discuss subjects in which the commission identified as those that would be addressed today. Is that correct, Mr.
Yeah,
Overstreet?
that's correct. They're available for any questions that commission staff or the parties might have.
Okay. And as we discussed at the beginning of the hearing, Kentucky Power may call those witnesses in whatever order it chooses to do so. So do you have the next one that you would like to call?
Right, we discussed this over lunch, and I think we'll stick for right now with the order we have, and so the next witness would be Tim Kearns.
Okay. Mr. Kearns, will you please raise your right, turn on your camera, turn on your microphone, and then please raise your right hand.
Good afternoon.
Good afternoon. Do you swear or affirm that the testimony you're about to give is true and correct under the penalty of perjury?
Yes.
Please state your name and address for the record.
Timothy Kearns, 2791 North US Highway 231, Rockport, Indiana, 47579.
Okay. Mr. Overstreet, Ms. Glass, you may ask.
Ms. Glass will ask.
Thank you. Mr. Kearns, can you please state your position and by whom you are employed?
Yes, I'm Vice President of Generating Assets for Kentucky Power, and I'm employed by the American Electric Power Service Corporation.
All right, and is it correct that you've been made available today by the company to answer questions related to any effect on generation planning or operations as a result of the strategic review of Kentucky Power, actions taken or decisions made with respect to the Mitchell Operating Agreement as a result of the strategic review, and the current Mitchell Operating Agreement?
Yes, that's correct.
Thank you. The witness is available for cross-examination.
All right. Mr. West, do you have any questions for Mr. Kearns?
No questions for the AG.
Mr. Kurtz?
Thank you, Your Honor. Mr. Kearns, is a general basic matter, is there any benefit to Kentucky Power in terms of decommissioning costs, ash pond closure, the delay of certain decommissioning costs, if West Virginia goes forward with the ELG and pays for all the ELG itself?
You're asking me about benefit, and I really think it's probably more appropriate to talk about which project or which installation complies with which rule. And, who benefits from what would be more of a legal question, and I'm certainly not a lawyer. So as Mr. Spitznagel testified earlier, the dry bottom ash conversion accomplishes compliance with both the ELG and the CCR rules.
So if West Virginia pays for all of that, does that then lower the burden on Kentucky? Had there been a CCR only by both states?
Again, you're asking me for a legal opinion. I'm more the day-to-day operation of the plant and the expenses associated with that.
Okay. Thank you, Chairman.
Mr. Childers? Mr. Miller?
Thank you, Mr. Chairman. No questions from Sierra Club. Thank you, Mr. Kearns.
Ms. Groneman?
Yes, briefly, Your Honor. Give me just a second. My camera appears to be lagging. Good afternoon, Mr. Kearns. How are you today?
Good afternoon. I'm well, thank you.
I believe I'm going to end up asking some of the questions that Ms. Bensel may ask, because I do have some questions about, you have been nominated as the person who may be able to answer some questions about the freeze on transfers that was put into
Yes.
place for Mitchell.
Yes.
Were you responsible for that decision?
I was.
And when did you make that decision?
Decision was made around on or around the 1st of June of 2021.
Okay. And what precipitated that decision?
The number of people who had applied for positions or internal transfers to AEP, as well as the overall head count at Mitchell, had started to drop off to a point that we were going to get concerned about the operation of the plant.
Can you tell me how many internal transfers you had seen, or what the number was at the time that you chose to implement that decision?
The number of actual transfers was fairly low. I believe it was only 2 at the time, but we had between 20 and 25 people who had applied for other positions within AEP.
Sorry, go ahead. I didn't mean to cut you off.
I'm sorry, I was just going to say that's out of a head count of 171.
And so I'm going to assume that the transfer portal is something that exists as on an ongoing basis within the company. Is that correct?
It does. It does.
And so,
And I'm so sorry. I need to correct something I just said. I said of a head count of 171, it was 187 at the time, and there were 20 to 25 of those who had, leading up to this decision, applied for positions at other places within AEP.
okay. And so my question is, for those 20 to 25 who had applied for other positions, over what time frame are we talking about that they had made those applications?
I don't know how early that started in relation to the announcement of the strategic review or anything like that. But it certainly would have been within the time frame. I mean, normally these postings go up and they're up for about 2 weeks, and then there's the process of selecting candidates and interviewing and what have you. So since the first of the year, I would say that number was 20 to 25.
Do you have any idea of the percentage of that 20 to 25 that were posted after the strategic review versus before?
I don't.
Did you believe that the postings were increased as a result of the strategic review?
Yes, I believe, not the postings. The number of people applying, I believe, was impacted by the strategic review. But, you know, there's also the uncertainty of the future of the plant. And so, you know, transfers really only account for one way that folks could leave. You also have retirements that are, you know, just out there because people are ready to retire. You have, like I say, the uncertainty of the future of the plant, the retirement date, and depending on where people are in their careers, and then you have the strategic review. So it was really a combination of all of those that led to the decrease in headcount. So the lever that I pulled was, let's put a temporary, or let's temporarily suspend the ability to apply for these internal positions. And that's what we did.
Is that suspension still in place today?
Yes, it is.
Do you have a time frame when you intend to resume allowing internal transfers?
Right now, the assumption is at the end of the strategic review. However, we'll look at our staffing levels at that point and see if we need to continue with that. We're actively looking to fill positions. And so, you know, as we get a number of positions filled, we may be able to relax that.
So what's the current head count right now?
Current head count is 163.
So I want to break that down a little bit. You told me that at the time you implemented the freeze on June 1 that you had a head count of 187.
That's correct.
And that now you're at 163, so you've lost 24 individuals?
That's correct.
And not as a result of transfers?
Not all. There have been 2 as a result of transfer, 5 total, 2 since the freeze or the temporary suspension went into play. And that may be confusing, but they were already in the process at the time we made the decision, so we allowed those 2 to go ahead and continue with the process. So a total of 5 have been lost to internal transfers. The rest have been retirements or resignations.
Can you tell me the breakdown between resignation and retirement?
I can't.
So you've had, of the 24, 19 of them have been resignations or retirements?
That's correct.
And in terms of your normal cadence of people overturning, is that 19 in a 4-month period unusual?
Yes, I would say it's unusual.
I don't know that I have any other questions. Thank you, sir.
Ms. Vincel, do you have any questions?
I just really one now. Can you describe, given what you said about this head count, what impact does that have on Kentucky Power's ability to provide reliable service?
To date, it's had no impact on the ability to provide, reliable service to our customers. It certainly has driven higher overtime percentages among the remaining employees, and we've made internal moves at the facility to help keep that overtime manageable. Our operations department was the one place that really required an action such as this because of the experience and the technical competence required to actually operate the units.
Just one more question. Can you give me your best estimate of the increase in overtime costs?
I don't have the cost. For the departments which normally would run 20% overtime, they're in the coal yard and in operations, we were running 30 to 50% coming through the summer months, but I haven't calculated that cost.
Staff has no further questions.
Vice Chair Cubbage, do you have any questions?
I do. Good afternoon, Mr. Kearns. How are you?
Good afternoon. I'm well, thank you.
I believe you have been thrown under the bus as our operating agreement person.
Oh, no, we're fine.
Okay. Well, I promise I am not going to ask you for legal interpretations of the document itself. I want to ask you basically how things have been working in practice and how, as far as the arrangement between the entities, as well as how you see changes coming down the pike in light of what the two different commissions have held. So with that being said, first I want to ask you about the operating committee.
Yes.
Is currently an operating committee?
Yes.
Okay. And I'm not sure what's going on. If you see me pause, it's because for some reason the video and audio for you is out of sync for me. And so the sound is coming after your mouth moves.
Okay, fair enough.
Okay. The way I read the operating agreement is either, plant upgrades and environmental upgrades are submitted to the operating committee. Is that is that happening?
Yes.
Okay, so did the ELG upgrade come before the operating committee?
The ELG upgrade came before the committee in terms of the committee members. There was not a single meeting to talk about the ELG upgrades.
Okay, well, and that's fair. And when I say that, I do mean generally. I don't mean you necessarily had a formal meeting. I know that meeting could be that it was sent out to all three members, currently designated members of the operating committee, and then they unanimously agreed, I take it, to go forward with preparations for the ELG upgrades. Would that be fair?
If it would be, if that's the recommendation of, that's brought forward, we would then talk about that and then we would just carve a path forward. So right now we have this situation where West Virginia is contemplating paying for the ELG, and Kentucky has said CCR only. So the operating committee is really waiting to get that ironed out before we see what we need to do.
Okay, so the operating committee has not officially blessed moving forward with the ELG upgrades? Is that correct?
That's correct.
Okay. Let's presume, and I know I'm asking you to, I'm getting out my crystal ball here. Let's presume, obviously, Kentucky, we've made our decision that ELG is not approved for Kentucky Power. And that West Virginia does in fact approve ELG to move forward at Mitchell with the full cost to be borne by West Virginia ratepayers. Do you see a path forward for the Kentucky Power representative of the operating committee to then approve the ELG upgrade?
So I would probably look to section 7.9 of the agreement. And I'm getting there now, if you'll bear with me. So from an agreement standpoint, the words there in 7.9 say that expenditures of the operating committee determines to have been or will be incurred exclusively for one owner shall be assigned exclusively to that owner. And then admittedly, I would say that the agreement is silent on what happens if the two jurisdictions have a different opinion on something that affects the retirement date, the potential retirement of the plant. So I would have to get back to Mr. Madison's testimony on some of the things that could be incorporated or may need to be incorporated in a revised operating agreement if that's the way we go.
Okay. I know there's been expressed some concern about the need for Wheeling to have a CPCN from Kentucky if it chooses to go forward with the ELG upgrade. Is that a fair statement?
I'm sorry, that's getting over into the legal side of things for me. I don't know.
Okay, that's fair. I was gonna, then let me ask this. Do you, in your role, see any barriers to amending the operating agreement to make Wheeling the operator of Mitchell?
Again, I'm going to caveat it to say that, I would need legal input on that. But with that said, in my current role, I don't see, there's nothing obvious to me that would prevent that.
Okay. So let's say the workers who were at Mitchell, presumably they are Kentucky Power employees because Kentucky Power is the operator. But if the operator changed, they'd simply become employees of the new operator. Would that be correct?
That would be my assumption.
Okay. So we're not talking about having to change a lot of the day-to-day operations. It would essentially be changes almost in name only, not for the accountants, I'm sure, but as far as operationally.
Yes, that's fair.
Okay. That's my last question. Thank you, sir.
Thank you.
Commissioner Butler, do you have any questions?
Not at this time.
Mr. Curran, who do you work for?
American Electric Power Service Corporation.
And American AEPSC, right? That's what,
Correct.
kind of like SWEPCO. I assume people refer to it as that, but I do. AEPSC is the agent in the Mitchell Plant Operating Agreement. Is that right?
Yes.
Okay. And so are you necessarily speaking, when you're, talking about your position, are you sort of, I guess, straddling that line on you're appearing on behalf of Kentucky Power, but work for effectively the agent as it's referred to as in the Mitchell operating agreement?
I think it's a dual role. I'm certainly a Service Corps employee, and I'm providing a service to Kentucky Power in addition to other operating companies. My role certainly also is as an agent as I bring recommendations forward from the generation side of the business to the owners and to the operating committee.
Okay. So you and the vice chair there were talking about the operator of the Mitchell Power Plant, right? Under the agreement, it's currently Kentucky Power. Is that your understanding?
Yes.
And do you have a copy of the agreement with you?
I do.
Do you mind to go to, I think it's page 6 of the agreement, but it's Article 3, titled Replacements, Additions, and Retirements.
I'm there.
Okay. And would you agree that this section deals with replacements, additions, and retirements as titled, but it's the replacements, additions, and retirements of capitalizable facilities?
Yes, I agree, that's what it says.
Okay, and so, is there a distinction between, certain operational decisions around, for instance, fuel, where the sections specifically talk about the interaction, how do I say this? The decisions surrounding investment in fuel, being made by Kentucky Power, the agent, and then some sort of determinations by the operating committee. Is there a distinction in terms of who makes decisions, or who this agreement says ultimately makes decisions around certain operating expenses versus capitalizable items?
I'm sorry, sir, can you repeat the question? I'm not sure I understand what you're asking.
I'll take a big step back. This agreement discusses an operating committee, right?
Yes.
And who is the operating committee made of?
Mr. Madison, Mr. Bean, the COO of Appalachian and Wheeling Power, and myself, and each of us have alternates.
Okay, so what, in your words, what does the operating committee do?
We make sure that the facility is operated and maintained in accordance, with this agreement, to the benefit of our customers.
Okay, so great. So let's skip just for a second then to Article 5. I think it's the following page in the document regarding investment in fuel. Do you see that?
Yes.
Okay. And so Article 5 discusses, and I'm just going to read part of 5.1 here. It discusses Kentucky Power Company and agent shall establish and maintain reserves of coal and stockpiles for the Mitchell plant of such quality and in such quantities as the operating committee shall determine. And then you see it goes on further in discussion, and then it discusses about interruptions and Norfolk fuel supply, and it says subject to the approval of the operating committee. Do you see those?
I do.
Okay, and then in the next section, apportionment of station costs. Section 6.1, let me know when you're there.
I'm there.
Okay, and the parenthetical, it says, in which case the allocation to the owners of fuel expense shall be in accordance with the procedures and processes approved by the operating committee. Do you see that?
I do.
And there are a number of other places in this agreement, particularly Article 7, which deals exclusively with operating committee and operations, in which this agreement notes what responsibilities, obligations, and rights that the operating committee has in regards to the operation of Mitchell, correct?
Correct.
Okay, so going back up to sections 3.1 and 3.2, and let me know when you're there.
I'm there.
Would you agree that the section regarding replacements, additions, and retirements of capitalizable facilities does not reference the operating committee?
Yes, I agree.
And does it reference Wheeling Power in section 3.1?
No, it doesn't.
Does it reference the agent in 3.1?
No, it doesn't.
Does it reference any entity other than Kentucky Power?
No, it doesn't.
And section 3.2 references only Kentucky Power and Wheeling Power. Is that correct?
Yes, that's correct.
And not the operating company, as we discussed earlier, correct?
I'm sorry, not the operating
Operating
company?
committee, excuse me, that was my mistake. Not the operating committee, as we discussed earlier, correct? It does not mention the operating committee?
Yes, that's correct.
Okay, and it does not reference the agent, is that correct?
It does not, that's correct.
Okay, so I'm going to read section 3.1, and you tell me if you disagree with what the document I have. It says, Kentucky Power Company shall from time to time make or cause to be made any additions to, replacements of, and retirements of capitalizable facilities associated with the Mitchell plant in accordance with the approved annual budget. Do you see that?
Yes, I do.
And you agree that's what it says?
I do agree, that's what it says, yes.
And then section 3.2 says the dollar amounts associated with any additions to, replacements of, or retirements of capitalizable facilities associated with the Mitchell plant shall be allocated to Kentucky Power and Wheeling Power in respective amounts proportionate to their ownership interests in the Mitchell plant at the time such additions, replacements, or retirements are made. Do you see that?
I do.
Okay, so this agreement, is it your understanding, is filed with FERC?
Yes.
Okay. And then are you an accountant by any chance, Mr. Kearns?
Lord, no, I'm an engineer, so probably worse.
Do you deal often with accountants?
Define often. I mean, certainly from the standpoint of developing budgets and variance reports and what have you.
Well, let me ask, do you have enough experience in this realm to appreciate the difference between a capitalizable cost and an expense?
Yes, I do.
Okay, and is it your understanding that effectively, and these are my words, but effectively an expense is realized in the year in which it's costed, and a capitalizable amount is recovered or expensed and realized over a number of years?
Yes, I do.
Okay. So capitalizable facilities are, well, would you agree that plant, property, and equipment are, as an ordinary matter, capitalizable facilities? With the exclusion of land?
To the degree that does fall within the established accounting rules, yes.
Okay. So this section, well, let me ask this. Is it your understanding that, based on the testimony today, well, let me take a step. I'll withdraw that. Do you have any, do you know whether Kentucky Power and Wheeling have discussed amending this section of the Mitchell operating agreement?
I do not.
Is it your understanding, as one of the three members of the operating committee, who I would assume effectively operates under this agreement every day, or acts according to it, that it's Kentucky Power under the current operating agreement that actually makes additions, replacements of, or retirements of capitalizable facilities associated with Mitchell today?
According to 3.1, yes.
And is there anything in this agreement that you're aware of that would allow Mitchell to make any additions to, make any replacements of, or make any retirements of capitalized facilities associated with Mitchell in this agreement? Are you aware of any provisions that would allow for that?
Can you repeat the question? I'm sorry.
Are you aware of any provision in this agreement that would allow Mitchell to make any additions to, any replacements of, and any retirements of capitalizable facilities associated with the Mitchell plant?
Your Honor,
Provision.
you said Mitchell, is that what you intended Mitchell make?
No, I'm sorry, Wheeling Power, excuse me. Are you aware of any provision that would allow Wheeling Power to make those additions, replacements, or retirements of capitalizable facilities associated with the Mitchell plant?
So I would probably have to defer to get a legal opinion on that, because as I pointed out before, from a day-to-day standpoint, if I look at section 7.9, it does allow for an owner to invest at the plant, and those costs to be borne exclusively by that owner. So I'm not sure I fully appreciate the legal difference between 3.1 and 7.9.
Okay, well, I'm glad you mentioned that, because it implicates the other part of section 3 that is discussed in 7.9, and that's the annual budgeting process. And can you explain to me, as one of the three members of the operating committee, what the annual budgeting process looks like in relation to this agreement?
Sure, it's really very similar to, or the same as what Mr. Madison testified to earlier. So from a generation perspective, we submit a budget, a plan.
Oh, excuse me,
But
Mr. Kearns, when you say "we,"
I'm sorry.
That's fine. Please continue. If you clarify who "we" is.
Thank you. The two generating facilities in Kentucky Power, the Big Sandy plant and the Mitchell plant, we put together a forecast, a plan for both capital and O&M expenses. We passed that on to Mr. Madison and his staff for consideration and review, as we do the same for Wheeling Power. And then it goes into that process that he described about as far as what they can afford and can't afford, and what investments will and won't be made, and that timing. And so as far as the committee goes, the members of the committee bring that budget or that proposal forward. We talk about that. I think the agreement requires that at least 90 days ahead of the end of the year, we bring that proposed budget forward, which we do, and then we hash that out.
Okay, so, lots of questions. So, is it your understanding, okay, you have this annual budget. Does 2021's annual budget include CCR and ELG compliance costs?
Yes.
Okay, and that's been approved by the effectively the triumvirate of the operating committee, is that correct?
Yes.
Okay, and so is there anything that keeps, even if ELG is denied, is there anything that precludes under the operating agreement from two or more of the members of the operating committee voting on a budget that the third does not approve?
Well, the agreement requires that, the agent is simply on the committee. The voting members are the two owners. So I wouldn't have a vote, if you will, or the agent wouldn't have a vote.
All right, so I guess I'd like to be clear. Is it your understanding from the agreement that unless it's in the annual budget or approved by the operating committee, capital expenditures can't be made to the Mitchell plant?
So is the question that no capital expenditure can be made at the Mitchell plant without the agreement of the committee?
Well, I think it's even taking a step back. Can there be capital expenditures, additions, replacements, or retirements that are not in line with the approved budget?
Yes, there can be.
Okay, and how is that determined?
Those would be emergent issues, and the example I'll give is the transformer failure that occurred at Mitchell on Unit 1 in April. That replacement was not in the 2021 budget. So when it failed, it became an emergent need, and so for anything greater than $250,000, I caucus with Mr. Madison and Mr. Beam, tell them what happened. We talk about the impacts, and then get their approval to move forward with that expenditure.
Okay. But you're effectively amending the budget, is that right? Well, let me ask you
At what
that.
level?
Are you amending the budget when you do that, or are you making a decision, is the operating committee making a decision outside of the annual budget?
We're not technically amending the budget. We're changing potentially the amount of money that gets spent at the facility. We may have other projects that are going to be underfunded, or underrun, and we can get the money to cover that cost from that project. So, Mr. Madison and Beam may not have to go find offsets for that money. We may already have it. So when you say that we're amending the budget, we're amending the actual how much money gets spent at Mitchell compared to what was originally planned.
Okay. So let me ask, I guess, a clarification here. the two parties get together, Wheeling and Kentucky Power. They come up with a budget. They approve the budget. The budget may be capital expenditures that are general in nature and applicable equally, whatever, in accordance with the cost allocation in this agreement. Or it may be a capital expenditure specific to one of the two parties, in which case this agreement already speaks to that. They come up with this budget, it's approved, it's sent up to AEP, it's sent back down with, let's say, yeah, you're gonna get 98% of that. And then you go into the operating year with that budget. And then under section 3.1 and 3.2, Kentucky Power is empowered to make those decisions that are implicated by the budget, the previously approved budget, and carry that budget out with regards to retirements and additions. Is that correct?
Yes, fundamentally, yes.
Okay. And so, I'll withdraw that. You were discussing earlier the effectively the transfer freeze. Is that a fair characterization? The transfer freeze from the Mitchell plant. Is that right?
Yeah, the temporary suspension of the ability of the employees to transfer within the company.
Okay. And you said that part of it you believe is related to the strategic review. Is that right?
Yeah, I mean, that's based on feedback from the plant staff and, informal discussions. There's been no poll that I'm aware of all the employees to ask them why.
Yeah, and I'm only asking sort of in your if you've heard it specifically or, whispers of it. I can only ask about your, personal experience and what you can personally speak to. But you mentioned that you believe, at least in part, I understood this from your testimony, that at least in part, the concern, in addition to the strategic review, was the uncertainty around the future of the plant. Maybe given the conflicting commission decisions or the fact that, the ELG or CCR compliance state. Is that correct?
Yeah, that's correct. And what I meant there is that some employees, depending on where they are in their career, may need to find another place to work if their personal situation is such that they need to go past 2028. And so some have started looking before, saying they just don't want to deal with the uncertainty. They know they have something else now.
Are you aware of instances in which that's the case for workers at either the Amos or the Mountaineer plants?
So, I'm sorry, can you repeat that?
Yeah, are you aware of whether that's the situation, a similar situation at the Amos or Mountaineer plants?
I'm not aware whether it is or not.
Okay, but, I mean, that's in part, well, do they have freezes at those plants that you're aware of?
No, not that I'm aware of.
Okay. Would you be aware?
I would be probably through meetings and conversations.
Okay. And is it your understanding that those two plants face similar decisions around regulatory requirements regarding CCR and ELG?
Yes, that's my understanding.
And I just want to make sure I understand, Mr. Kearns, because I have questions about other agreements. Are you here specifically to discuss, or only to discuss the Mitchell operating agreement?
Yes, I mean, in depth. I know there are other agreements that affect the way the Service Corps provides services to the different operating companies, such as the barging agreement and the spare parts agreement. I certainly don't know those in a lot of detail, but I'm aware that they're out there.
Okay. And other than your decision regarding and these are again my words, to freeze the transfers at Mitchell and Big Sandy, have you made any other decision that's been based in whole or even in part because of the strategic review AEP announced for its Kentucky assets?
No.
Those are all the questions I have for Mr. Kearns. Do you have any redirect?
Just one, I believe. And Mr. Kearns, if I can direct you back to the Mitchell operating agreement, will you let me know when you have that up?
I have it.
Okay. So I'd like to ask you about section 3.1 that the chairman was asking you about. Do you have that in front of you?
Yes, I do.
Okay, so that section says that Kentucky Power shall from time to time make or cause to be made any additions to, replacements of, and retirements of capitalizable facilities associated with the Mitchell plant in accordance with the approved budget, correct?
Yes, it does.
The approved annual budget. I skipped a word. Okay, so if I can then direct you to section 7.2A, can you let me know when you get there?
I'm there.
Okay, so that section says, the operating committee shall have the following responsibilities. A, review and approval of an annual budget and annual operating plan, and then it goes on, correct?
Yes.
Okay, so it would be the operating committee that would approve the annual budget, correct?
Yes.
Okay. Thank you. That's all the questions I have.
Ms. Vinsel, is there any reason that Mr. Kearns can't be excused?
He can be excused.
Thank you very much, Mr. Kearns.
Thank you.
Ms. Glass, Mr. Overstreet, do you have an additional witness?
Yes, Amanda Connor.
Okay. Ms. Connor, if you will, please, is she in the room
I believe she is.
at the dais? Whatever. Don't know how else to explain the setup there. Please make sure your microphone is on, your camera is on, and please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
My name is Amanda Riggs Connor. Business address is 1 Riverside Plaza, Columbus, Ohio.
All right, thank you very much. Ms. Glass, Mr. Overstreet, you may ask.
Thank you, Mr. Chairman. Ms. Connor, by whom are you employed?
I'm employed by AEP Service Corporation.
And in what position are you employed?
I'm the Vice President of FERC and RTO Strategy and Policy.
And briefly, what does that entail?
That entails advocating for our company policy positions as it relates to FERC regulation, and also our policy positions within the RTOs in which we operate, which would include Southwest Power Pool, PJM, ERCOT, the Midwest ISO, or MISO now, Mid-Continent ISO.
Okay, thank you. And are you familiar with the Kentucky Power Company's notice of filing of witness list that was filed in this case on Friday, October 1st?
Yes, I am.
And you're here to testify based upon your knowledge concerning the issues described in that notice as it pertains to you?
That's correct.
Okay, thank you. I believe the witness is available.
Thank you, Mr. Overstreet. Mr. West, do you have any questions for Ms. Connor?
No questions.
Mr. Kurtz?
No question, Your Honor.
Ms. Vinsel?
No questions.
Vice Chair?
No questions?
Commissioner Butler?
No questions.
I'm going to come back because I completely skipped him. Mr. Miller, Mr. Childers?
No worries, Your Honor. Thank you. None.
Ms. Grumman?
No questions, Your Honor.
Thank you.
That was just hopeful thinking that we were all going to be in the room. I understand.
Good afternoon, Ms. Connor.
Good afternoon.
I have a lot of questions. To be frank, and I promised, I didn't promise, I don't want to say I promised. I told Mr. Overstreet at our formal conference in this matter that we expect to probably have more hearings on this. But I do have some initial questions that I believe are a bit timely that hopefully you'll be able to help with. Have you reviewed any of the agreements that have been filed in this case? And specifically, I guess it's been incorporated in this case. Specifically, I'll find it here. Incorporated into this case was AEP, I guess it's technically APCO's rate schedule number 300, which is a power coordination agreement between APCO, I&M, Kentucky Power, and Wheeling, along with AEP SC as the agent. Are you aware generally of that agreement?
Yes, generally speaking.
And
Excuse me, Your Honor, I apologize. I cannot hear what she's saying. Is there any
Okay.
way we could increase the volume here in the hearing room?
we can try to increase the volume, and then we can ask Ms. Connor if they're able to increase their microphone volume as well during the room.
I think it's me and not the technology, but it's still.
So give us a second, and we'll increase our volume as much as we can without concern for our speakers. And I would ask if the folks there in Columbus, I assume that's where they are, in Columbus can increase the microphone, if Ms. Connor has the ability to move closer to the microphone.
I apologize for interrupting.
I'm not that tall, so I can't get that close. Can you hear me? No. What's that? DJ close? Okay.
That's much better.
Is that any better?
Yes.
Yeah,
Thank you.
it is better. We just may ask that you sort of, I have this effect sometimes, maybe yell a little bit, and I think it'll work well.
I can yell.
Okay. All right. So, Ms. Connor, have you recently, in the last few weeks, days, been able to review that power coordination agreement?
I've looked through it, yes.
Okay. So do you have it available to you right now?
Yes, hang on a second.
Your Honor, I apologize. We apparently are printing out that agreement, and if you wanted to address a different agreement and then jump back, she just doesn't have it in front of her right at this moment.
Yeah, and I think I can ask quite a few questions about PJM's, or the interaction of PJM before I even get to the specific parts of the agreement. So, Ms. Connor, can you hear me?
Yes, I can.
So while we're waiting on you to get a copy of the agreement, I would just ask, how familiar are you with Kentucky Power and AEP SE as Kentucky Power's agent, their interaction with PJM?
I'm generally familiar. I'm not the one that has kind of the day-to-day interactions with PJM. So I can answer to the best of my ability. But, you know, I'm not the interface between AEP, SC, and PJM, or any of the operating companies in PJM.
Okay. So is there someone else that can speak more to the creation and the annual membership and the interaction between the FRR plan, Kentucky Power, and PJM?
I can speak generally. Alex Vaughn, who's another witness identified in this case, may be able to speak more to that.
Okay, so we'll start with you, Ms. Connor, and you can just throw on to Mr. Vaughn any questions that he can blame you later. My understanding of the FRR plan is that a significant number of the AEP East operating companies participate jointly in an FRR plan that's filed with PJM. Is that your understanding?
Yes.
And is it also your understanding that a portion of that, or maybe a significant amount of that, how that interaction occurs and how that plan is created, is laid out in the, let me get it right, the Power Coordination Agreement?
Yes.
Okay. And so with the FRR plan, is it your understanding that that's effectively, that's a way in which a entity can become a full member of PJM, turn over the functional control of their transmission system, and be a full-fledged member without necessarily participating in the annual base residual auction capacity market?
I'm not sure I understand the question there, as far as participation in PJM as a member. The
So
AEP operating companies are transmission-owning members of PJM
Yeah, so
and participate in the market.
is it your understanding
I don't
that
understand your
PJM
question.
members, full-fledged PJM members, fall into primarily two categories? Those that participate in base residual auctions and those that satisfy their capacity requirements through the FRR construct?
Yes, it's my understanding that you can either participate in the base residual auction, subject to the standard reliability pricing model, or you can satisfy your capacity obligations using the FRR alternative.
And it's one or the other, right? You can't be a member and then say, well, we're vertically integrated, we're just going to hang out over here. It has to be, we're vertically integrated, but we'll comply and provide you an adequate FRR plan. Is that your understanding?
My understanding is, yes, that you have to make the election to be an FRR if you wanted to be excluded from the base residual auction.
Okay. And Kentucky Power, along with some of these other affiliates, are they go in together for an FRR plan. They don't do it on an individual operating company basis. Is that your understanding?
That's correct.
Okay. And is it your understanding that Kentucky Power has enough capacity to serve, to meet its, let me take a step back. Are you aware of what PJM has said Kentucky Power's obligations in terms of capacity are versus how much capacity that Kentucky Power currently has, whether it's adequate, long, or short on capacity as a standalone operating company?
No, I'm not aware.
Okay. Is that a better question for Mr. Vaughn?
I think so, yes.
Okay. Are you aware of any of the, if I wanted to ask about any of the other members of the Power Coordination Agreement, APCO, I&M, or Wheeling, as to whether they're long, short, or adequate on capacity as it relates to a standalone FRR plan, are those also questions for Mr. Vaughn?
Yes, thank
Okay.
you.
Are you aware generally of the RAA or the PJM Reliability Assurance Agreement?
I'm generally aware of it. That's not an agreement that I've looked at for a while, but that is how the RPM is designed.
And are you aware of attachment DD of the PJM, or actually, let me take a step back. Are you aware generally of the PJM open access transmission tariff as it relates to the, excuse me, I'm going to withdraw all of that because that was very confusing. Are you aware of those attachments to the PJM open access transmission tariff related to the AEP East companies generally, not even the specific attachments, but that there are attachments related to the companies?
Yes, I am aware.
And is it your understanding that the primary interaction, although Kentucky Power is a member, the primary interaction between Kentucky Power and PJM is through AEPSC as agent?
I think that's a fair statement.
Okay, and that relates not only to things like the RRA, or excuse me, the RAA, but also the open access transmission tariffs?
Yes.
Okay. And are you generally aware, well, I withdraw that because I know that Mr. Vaughn is. Are you aware of any direct interaction between Kentucky Power and PJM?
I am not aware of who interacts with PJM from Kentucky Power specifically.
Do you have anyone that works for you, with you, or in your division that is an employee of Kentucky Power or works exclusively on behalf of Kentucky Power?
No, there's no one that reports through my team who works directly for Kentucky Power.
Okay.
They're Service Corps employees.
Okay. And insofar as there are generation hedges or off-system sales or off-system purchases, any changes to the PJM operating documents, those, if those affect Kentucky Power, the entity that is representing Kentucky Power in any of those transactions or dealings is an AEPSC employee. Is that correct?
That would be my understanding and assumption based on the way our general interactions with PJM go.
Okay. Well, thank you very much, Ms. Connor. Do you all have, Mr. Overstreet, do you have any redirect, Ms. Glass, for Ms. Connor?
No, Your Honor.
Okay. All right. Thank you very much, Ms. Connor. You may, any reason that Ms. Connor may not be excused?
She may be excused.
All right. Thank you. Enjoy the rest of your day, Ms. Connor.
Thank you. You do the same.
It's been an hour. Are you going to call Mr. Ali next?
Yes, with the
I'd like to
commission's
do
permission.
yeah, I'd like to do the group a favor. I'd like to take probably a 13-minute recess until 2:30. And then you may call your next witness after that recess.
Sure.
Thank you.
Thank you, John.
All right. Now, can you hear us, Commissioner Butler?
Yes, thank you.
Perfect. We weren't on the record yet. I was complaining to everyone about my appliance woes. We're back on the record in case number 2021-00370, electronic investigation of the service rates and facilities of Kentucky Power Company. Ms. Glass, Mr. Overstreet, do you have additional witnesses to call?
Yes, Your Honor. Kentucky Power presents a Cameron Ali.
Mr. Ali, please turn on your camera, your microphone, and raise your right hand. Do you swear and affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Okay. Mr. Ali, before we get started, do you mind to pull the microphone as close to you as possible?
Yeah, Your Honor. Is this any better? Are you guys able to hear me all right?
Is that okay, Mr. Overstreet?
That's fine, thank you.
Okay. I'm not asking for my benefit, I'm asking for your attorney's. So, if it can go closer, I know you may have left it further away to dig at me. So it's for Mr. Overstreet's a benefit at this point. I think I have a speaker close to me. So, Mr. Ali, will you please state your name and address for the record?
Cameron Ali, 8500 Smiths Mill Road, New Albany, Ohio, 43054.
Mr. Overstreet, you may ask.
Thank you, Your Honor. Mr. Ali, by whom are you employed?
I'm employed by American Electric Power Service Corporation.
And what is your position with Service Corps?
I am currently the Vice President of Transmission Planning for AEP.
And are you here to answer questions on those topics identified in the October 1 notice of filing a witness list in this proceeding?
Yes, I am.
Okay. The witness is available.
Thank you. Mr. West, do you have any questions for Mr. Ali?
No questions.
Mr. Kurtz?
No questions.
Mr. Childers? Mr. Miller?
None, thank you, Your Honor.
Ms. Grunman?
No, thank you, Your Honor.
Ms. Vinsel?
None.
Vice Chair Cubbage?
No questions.
Commissioner Butler?
No questions.
Okay. Mr. Ali, good afternoon.
Good afternoon, Your Honor.
How long have you been employed with American Electric Power?
Your Honor, it has been a little over 15 years now.
Okay. Have you worked primarily or exclusively in transmission planning?
Yes, Your Honor. Primarily, most of my career I've spent in transmission planning. Before that, I was in substation design engineering.
Okay. So, and you should never go from memory, but has AEP and Kentucky Power been a member of PJM the entirety of, or have AEP, has Kentucky Power, we'll just say it was Kentucky Power, has Kentucky Power been a member of PJM through most, if not all, of your time at AEP?
Yes, Your Honor. For the entirety of my career at AEP, Kentucky has been a member of the PJM RTO.
Okay, and coincident with that, so has a number of other other AEP East operating companies. Is that correct?
Yes, all the AEP East operating companies are members of PJM RTO.
Okay. I presume something, Mr. Ali, so correct me if I'm wrong. I presume that, and I'm just going to, since you work for all of the operating companies or on behalf of many of the operating companies in the AEP system, I'm just going to ask generally and then we'll get into specific questions about Kentucky Power. But I presume that there are certain transmission planning functions or activities that the companies take that would be identical to those that they would take if they weren't part of PJM, and that there are likely actions or processes the companies have to partake in that they wouldn't necessarily if they weren't part of PJM. Is that fair?
Your Honor, it's a pretty loaded question, so if you allow me, I probably would like to answer that in parts. So part one is that are there activities that the companies would take regardless of them being a member of the RTO from a planning perspective, from a transmission planning perspective? And the answer is yes, there are certain compliance obligations that must fulfill regardless of them being members of the RTO or not member of the RTO across the country. And then are there activities that are additional that the companies have to undertake because they are members of the RTO? And the answer to that question is also yes. There are certain additional requirements that are in the tariffs of the respective RTOs that the companies have to undertake as members of the RTO.
Okay, so are they substantive processes or are they, well, I withdraw that. Can you tell me the major, have you been watching the hearing for the entirety today, Mr. Ali?
For the most part, Your Honor, not the entirety.
And did you get to see the portion of the hearing in which I was asking Mr. Madison questions regarding the level of input required from the AEPSC organization related to budgeting and capital plans for the generation and transmission functions of Kentucky Power?
Yes, Your Honor, I did watch that.
Okay. And I mean, is there anything that Mr. Madison said around the transmission function that you would necessarily disagree with?
Your Honor, I won't disagree with anything Mr. Madison said, and Mr. Madison was explaining the process in general, and of course the process definitely is a lot more, it has a lot more granularity to it. You know, the only thing that I would say in summary is that my job function is to assess the adequacy of the transmission grid in respect to the standards, guidelines, best engineering practices that are established. And then my job is to share those needs with the operating companies, including Kentucky Power and Mr. Madison. And then Mr. Madison and his direct reports and the staff, they have make the determination as to which needs on the transmission grid will be addressed and what will be the funding mechanism for that.
Okay, and that's what I kind of want to talk about. He picked up that question from the perspective of, well, his interaction, I guess, with your group, right? What he's receiving from you and then where that information goes. I'd like to ask you necessarily, and not in extreme detail, but at a fairly high level, the process you're going through to identify the needs, to determine what the annual capital plan or capital budget, what processes you all are going through to identify those inputs that you're providing to Mr. Madison that he was discussing in the context of the capital plan.
Yeah, Your Honor, it's a pretty detailed process, so I'll try to stay at high level, and if you need to want me to dig into any sections of that process in more detail, I'll be more than happy to do so. Before I do that, though, I would like to explain that there are standards that are determined by external entities, such as NERC or the RTO. Then there are standards and assumptions and guidelines that we have as a utility to ensure that we are meeting our fundamental obligation to serve our customers in a reliable and cost-effective manner. Those standards that are internal to AEP are developed in collaboration with our affiliates such as Kentucky Power. So, Brett Madison, his team, and his staff, they are involved, and at their direction, we develop those standards and guidelines. Once those external standards and internal standards and guidelines are all developed and known, we then assess the adequacy of the grid against those. And as a result of that, we would come up with needs on the transmission grid. I'll just give you a high-level example. Maybe there is a transmission line that has significant deterioration over the past few years, and it has resulted in certain numbers of customer minutes of interruption. That will be a need that we will identify. Our job then is to take those needs to Mr. Madison and his staff so they can determine what should be the timing of addressing that based on availability of funding and the budget. So really, the solutions as well as the timing of development and implementation of those solutions, that is done in collaboration and per the direction of the operating companies, including Kentucky Power. And those were the meetings that Mr. Madison was referring to in his testimony earlier.
So, the example you just gave there, would you describe that as an issue with the condition of the line?
Your Honor, most of the time the issues are related to condition of the line. Sometimes the condition may result in performance, and sometimes the performance is not showing up on the radar as of yet. But again, it's a risk in the future if you don't address the condition. So most of the investment, I would say, around asset renewal or asset rehabilitation is really around obsolescence or condition of the assets.
Okay, so based off that hypothetical you provided about the deterioration of the line, which is a asset condition issue, and then there are associated customer minutes of interruption, a specific amount on an annual basis, a certain number or calculation of CMI, right? Let's separate those for a minute. Who is the CMI measured by? Kentucky Power or AEPSC?
So, Your Honor, the CMI actually is measured by a database called OMS, Outage Management System. That is a distribution database, by the way. So, I am not in a position, I just don't know who manages it. I think it is an AEP Service Corporation managed database, but all the input into that database is from the operating companies. So the operating companies, as the outages are happening, their employees are logging those outages onto that database, depending on if the outage is on the transmission side or the distribution side. So we are utilizing that database to see the actual performance of our assets.
Yeah, and most of my questions, Mr. Ali, will effectively surround that interplay between the operating company and AEPSC and the functions that it plays. So what I want to understand to make sure that I'm understanding is you have an outage, right, or you have a number of outages over a defined period. It's the distribution function of the utility that's noting that they have certain areas of the distribution system that are not being fed electricity from the transmission system, and they log those and provide that data on an enterprise level. Is that effectively what you're saying?
Your Honor, just to clarify that, so the outage is being recorded in the outage management system by the employees of the organization that is responding to those outages. And really, when there is a storm out there or there is an outage out there, we got protocols established as to who's going to go and respond to it. Most of the distribution outages, Kentucky Power Field Services individuals will respond to. Even for some transmission outages, they would respond to. Most of the transmission outages, we will have transmission field services employees respond to. And those are the individuals who are responsible for logging those outages and how much time the outage was. Our customers experienced that, how many customers were out as a result, what was the cause of that outage. All that is logged, by the employee, depending on, I guess, the outage, who will respond to that.
And are those operating company employees at the transmission level, or are those AEPSC employees at the transmission level?
Subject to check, Your Honor. My understanding is that those are AEPSC employees in the transmission field services organization. However, like I mentioned earlier, there are employees responding on the distribution, for distribution outages. And those employees, my understanding, are employed by Kentucky Power Service Corporation.
Okay, and then there are, you're aware of the 765 lines running through Kentucky, correct?
Yes, Your Honor, I am.
Okay, and those would be the people that would be going out to service one of those outages aren't necessarily Kentucky Power employees. They're likely AEP-SC transmission employees. Is that accurate?
Your Honor, yes, those will be transmission field services employees who are employed by APSC.
Okay, and then for those facilities that are owned by AEP, I'm trying to get it right, Mr. Overstreet. AEP Kentucky Transmission Company facilities. For those facilities, if there are outages or material or condition issues, are those Kentucky Power employees that go and service those if there's an outage, or are those exclusively the transmission field services employees?
Your Honor, I think there is maybe some confusion there. Let me clarify that. So we have two organizations that do the field work outside. One is we refer to them as transmission field services, and the other one is distribution field services and operations. And those are the only two entities and any contractors that they may have on as staff augmentation that respond to outages. For transmission outages, especially line outages that are outside the substation, transmission field services organization responds to those. And for distribution outages that are inside a substation or on distribution lines outside a substation, depending on, and again, I'm not privy to all the protocols there, but we have some protocols that have been established. Depending on those protocols, some of those outages distribution employees would respond to in substations, and some of them transmission field services employees would respond to. And as far as distribution outages outside substations are concerned, in most cases, those are responded to and attended by distribution field services and operations employees.
Is there a distinction made that you're aware of in the planning documents between those transmission, how the response is coordinated between those transmission facilities that are owned by Kentucky Power and those that are owned by AEP Kentucky Transmission Company?
There is no distinction whatsoever in not only responding to these assets when there are outages, but also in how we plan those facilities. The Transco affiliate of Kentucky Power was just a financing vehicle, nothing more than that. And since the order of the commission in our last proceeding, going forward, we don't have any assets that will be owned by AEP Transco Kentucky going forward.
Well, there will be no expansion of those that are owned by AEP Kentucky Transmission Company. Is that what you're saying?
Your Honor, I'm sorry, you will have to elaborate on that.
Yeah. Is it that the rate base is not expected to increase, or that there's a plan to transfer those assets to Kentucky Power?
Your Honor, I'm not aware of any plans at this point. I think Mr. Madison will be in a better position to answer if there are any plans to transfer the existing assets that are already part of Kentucky Transco. But what I am able to state is that going forward, no new assets will be added to the Kentucky Transco.
Okay, so you say the only difference is the financing, but those are are you under the impression that those facilities are under different control?
No, Your Honor, those facilities are under the same control and same provisions apply to them that the Kentucky transmission assets are under.
So those are under the control of Mr. Madison?
Yes, Your Honor, that's my understanding. The physical assets themselves, I think, is what we're referring to, in the sense that who responds to them, who plans for them, the planning for those assets, the restoration for those assets is exactly the same as it is for the Kentucky transmission assets.
Okay. So I'd like to talk about, So we discussed earlier an example of you coming up with, your group coming up with what the need is based off of transmission condition, right? You had a transmission line that was in poor condition. It was leading to a certain number of customer minutes of interruption in a specific time period, and you make a recommendation for, repair, replacement, whatever it may be, to fix, we'll just say a solution to that identified problem, that you present that to Mr. Madison, you give him information over the time horizon that you would recommend that it be fixed, and then it's in his hands effectively as the COO in where he wants to include that in the capital plan to provide to AEP. Is that correct?
Yes, Your Honor, that is correct.
Okay. And then, so let's talk about it from that perspective. Everything up to that point, for a scenario like that, is that the same whether or not you are, or Kentucky Power is or is not a member of an RTO?
Your Honor, for the most part, there are definitely certain additional assessments that we have to perform, being member of the RTOs that result in additional needs. For example, PJM performs a generation deliverability and load deliverability analysis every year, and they do it for the bulk system, 100 kV and above, and we do that for the non-BES, the non-bulk electric system below 100 kV. So those are additional analysis that we do as members of PJM.
Yeah, and that, I appreciate you. I appreciate you making that distinction, because I do want to get to that point. So, but based off exclusively condition, right? Let's say end of life criteria, effectively. Is there a major distinction whether or not Kentucky Power is part of an RTO as the way that you all would identify those needs?
No, Your Honor, it is exactly the same. As a matter of fact, it is the same for all Western companies who are in SPP and ERCOT RTOs.
Okay, so then you have those needs that are not related to condition necessarily, that may be based off of identifiable standards, right? And those may be tests that you conduct, and those might be tests and studies conducted by PJM. Is that your testimony?
That is correct.
Okay,
Yes.
and those can be criteria that you all set on a company or enterprise-wide basis, or they can be criteria set by a FERC-approved methodology through the RTO, correct?
That is correct.
Okay. And those are, I say standardized, those are at least, we may not have we may not receive a copy from the company each year, but somewhere in one of these cases, we have those criteria. Is that probably fair? It's somewhere in Discovery, AEP has probably given us what those enterprise-wide standards and criteria are. Is that right?
Your Honor, I think that's a fair statement.
Okay. And those are reviewed annually as a FERC-approved transmission planning process at PJM?
Yes, Your Honor, that is correct for the PJM footprint. Those assumptions, criteria, standards that are used to assess the adequacy of the grid are reviewed with stakeholders on an annual basis.
Okay. Can you tell me one of those? You were saying earlier. Well, let me ask this: do you review each year for voltage and thermal violations on your own system for those non-BES facilities?
Yes, Your Honor. Are you talking about I'm assuming you're talking about the criteria document, not the results of the analysis. I just want to clarify that before I answer that.
Yeah. Let me ask you this way: what criteria or studies are you conducting that are not necessarily required? What are you all doing on your own? Either ones that are non-BES, right? So that PJM basically defers to your studies or allows you to study, or criteria of your own? What studies are you all doing each year looking for certain violations of criteria or rules?
Your Honor, so before I maybe answer that, I want to clarify something. So there are many drivers for transmission needs. There are external drivers for those needs, and there are internal drivers for the needs. So the external drivers could be a new customer requesting connection to the grid. It could be a generator requesting connection to the grid. It could be a contractual obligation to relocate a line that was built on public right-of-way. It could be a compliance change, that requires us to make changes to the components of the grid. So there could be a lot of external drivers, and those drivers may or may not be driven by the RTO. Of course, if there are obligations that we have, we would meet those obligations. Similarly, there are internal drivers, which include safety, modernization, resilience, telecommunication, SCADA investment, and of course, obsolescence and asset renewal. I think your question is which one of these different types of needs that are coming into the mix are driven by the RTO and which ones are not. So really, the only RTO-driven needs in that file are the RTO and NERC criteria violations, which are really load flow and stability analysis and assessments that the RTO performs on a yearly basis. That is based on the RTO standards that are FERC approved in their manuals and processes, as well as any bulk electric system standards that the RTOs need to abide by as a transmission service provider or a transmission planner. On the AEP side, in addition to all the different drivers that I mentioned, we also have criteria for load flow and stability analysis. And we have pretty much adopted the NERC transmission planning standard, which happens to be the bare minimum planning standard in the industry for our non-bulk electric system, because the RTOs are planning for the bulk system top down, and we are planning for the non-BES system bottom up. So that's the only criteria-driven, element of the planning as a result of the load flow and stability analysis that we bring to the table.
Okay, so after Mr. Akins and Ms. Sloat have approved and sent back Kentucky Power's plan that I was talking about with Mr. Madison earlier, the annual capital plan, and sit back and said, this is your allocation. We've approved your proposal in total, right? Mr. Madison is very satisfied. This is great news. I need to go back and get hold of Cameron, because we now need to follow through on these needs that the AEP SC Transmission Planning Group told us we had, right? So they told you told him there were needs. He put them in his capital plan. The capital plan got approved. What happens after that, Mr. Ali?
Yes, Your Honor, it is, as Mr. Madison said, it's a top-down, bottom-up approach. So, we are telling Mr. Madison what the needs are. Mr. Madison is then communicating and translating all those needs from transmission, distribution, generation into what the budget should be to address them. And of course, depending on how much, or if let's say all of that need gets approved, then Mr. Madison will come back and will give us direction concerning which of those projects, based on the availability of dollars and resources, we are able to then undertake. Once I get that direction from Mr. Madison on which projects we can move forward, then of course my job then is to engage those projects with a broader organization, which includes our engineering, project management, construction management groups. We also, reach out to external entities if there are filing requirements like CCN, and of course Mr. Madison's staff determines the filing requirements for those projects as well. And we also make sure that the RTOs and stakeholders are kept up to date on the progression of these needs, from needs to projects and then through execution. And as those projects are being executed, we have quarterly meetings with Mr. Madison and his team to apprise them of the development of those projects. And if we are running into any issues concerning the scope, the schedule, or cost of those projects, And then if there are issues, then we seek guidance and direction from Mr. Madison and his staff to address those types of issues and challenges.
Okay, so one of the specific things you discussed, let's just talk about two scenarios. Two scenarios here. One is a need is addressed through a PJM study for a BES facility, right? And to make things far easier in this hypothetical, that it's 3 years out. So although it is a BES facility and it's at a fairly high voltage, it falls under the immediate need exception to the requirement that it be competitively bid. So AEP, Kentucky Power, as the entity that owns the facility, is the designated entity and therefore proposes a solution to PJM. Is that correct?
Yes, Your Honor. For near-term needs, the incumbent transmission owner gets to propose the upgrade for that. So in this case, hypothetically, it's Kentucky. So Kentucky Power will propose that idea.
Okay, and so I just want to make sure I understand process-wise the interaction between PJM, your group, and Kentucky Power. And so PJM conducts the study, right? Conducts their RTEP. The significant violations on a particular facility are identified, and I know they don't call them, but they call up Mr. Madison and they say, we got a need in your neck of the woods. It's shown up. Here are these violations, and so your group is working towards finding a solution to that violation in concert with Mr. Madison and in concert with that capital plan. Is that correct?
Yes, Your Honor. So PJM is working with my organization directly in sharing the needs on the grid. And my organization, we work on direction from Mr. Madison and his staff on addressing the needs that PJM identify in the most cost-effective manner.
Okay, and that's an important distinction, is that the interaction with relation to transmission planning is between your group and PJM, not necessarily a transmission person at Kentucky Power. Is that fair?
Yeah, Your Honor, that is fair. I'm not aware if there is any transmission planning expertise at any of our affiliates. Those expertise are at the AEP Service Corporation, and we are, as a result of that, we provide our services to our affiliates across the company. And again, for PJM transmission planning to discuss issues that they uncovered, they definitely would, discuss those with somebody who can speak the same language, and that would be the transmission planning organization at AEPSC. Of course, it is our responsibility that we take that information from PJM, and then we work with the respective affiliates to ensure that the system is being addressed in accordance with their desires and with their strategic vision for that area.
Okay, and that's what it's only been an hour, but that's what we're building up to, Mr. Ali. Is there are stakeholder meetings at PJM regarding transmission planning. Is that correct? Subregional RTEP being one of them.
Yes, that is correct.
Yeah, and subregional RTEP, I always get annoyed when other people do it, but it's kind of a misnomer because the R in RTEP stands for regional, so it's really the S RTEP, right? The sub RTEP. Is that right?
That is correct. I think it is called regional transmission expansion plan. So yes.
Well, that's just silly. That's silly to have the regional in there twice. But so it's a sub-regional RTEP, and the majority of the sub-regional RTEP meetings are regarding supplemental projects. Is that, and I don't mean all the projects discussed in the sub-regional RTEP, but ordinarily that's where the supplemental projects are discussed. Is that right?
Your Honor, you're right. They're not all the projects are supplemental. There are some baseline, and not all supplemental projects are at sub-regional, but most of them are.
Yeah, and then there is another meeting that's similar to the sub-regional RTEP that is more about the BES. And what meeting or what stakeholder meeting is that?
That's the Transmission Expansion Advisory Committee, the TAC meeting.
Okay, and the TAC, you've participated in these TACs, and other people with AEPSC participate in these TACs to propose and discuss or to discuss proposed solutions, identified problems, needs for certain transmission projects for their particular system. Is that accurate?
Your Honor, there may be other AEP, SC, and even or affiliate employees participating in those meetings from time to time. But to propose and discuss the ideas, that responsibility is only with my organization, and we do that on direction from the affiliates, such as Kentucky Power.
And this is what I want to get to, Mr. Ali. Occasionally, those will be a project in Kentucky that will be a Kentucky Power facility, right? It'll be a BES facility that has a thermal violation X number of years out. And someone from AEPSC is on the line to discuss what solutions there, what alternatives were considered, why the cost is this, why the bus is designed to look like X. It's all Greek to me. But there's somebody there from your group that's talking about it as a subject matter expert. Is there somebody, when it's a Kentucky Power specific proposal or issue, is there somebody from Kentucky Power that is present on those?
Your Honor, I really can't say with certainty that they're not present in those meetings. What I can tell you is that before we go into those meetings, these types of issues are discussed holistically as portfolios in the collaboration meetings that Mr. Madison referred to. You know, we have a 5-year portfolio for transmission, so even 3-year out problems are already in our portfolio. And even the problems that the RTOs are identifying, we have the same tools at our disposal. So we analyze that beforehand. We know what issues the RTOs may find. Of course, we won't trigger anything till the RTOs confirm that they indeed see the same issue. So the portfolio of these projects has been discussed ahead of any outreach external to Kentucky Power. So again, I can't answer if they do or don't participate. There may be time to time, they may be listening, because there are a lot of observers that call into that, and some of those folks call in using their phone number. So it's very difficult to decipher who may be or may not be there. But they absolutely have the ability to do that, and we do have conversations with Kentucky Power before we take any projects or needs through the stakeholder process.
Yeah, let me ask this: Are you aware of any specific instances in which you know a Kentucky Power employee did participate in one of those TAC meetings?
Your Honor, like I said, I'm not aware. And again, I'm not aware. There are many people that call in. I'm not sure with certainty who all calls into that meeting unless people announce themselves.
Okay. Are you aware generally of the SIP 14 standards?
Yes, Your Honor, I am.
Okay. And those are my word would be touchy, but those are sensitive facilities that fall under that SIP 14 standard, correct?
Yes, Your Honor, I think that may be one way to put it. Those are critical assets that are very critical to the viability and reliability of the grid.
Okay, and is there anybody at any of the operating companies, let me withdraw that. Is there anybody that you're aware of at Kentucky Power that has the wherewithal or the experience or the wherewithal or experience to identify SIP 14 facilities, or does Kentucky Power depend on AEPSC to do that?
So, Your Honor, if there were SIP facilities, and by the way, I think I need to clarify that. Of course, this will be all confidential information concerning whether there are SIP assets or no SIP assets out there. So I'm just going to talk about hypothetically that if there was to be a SIP perform analysis, that analysis would be performed by my organization. We have the expertise for the entire AEP service footprint to perform such an analysis, and then such an analysis will be ratified by the respective RTO. So it's not just that an entity can perform that analysis; it has to be ratified by a third party. In our case, that third party is the RTO, and it can be somebody else that an entity may decide to hire.
Yeah, and I don't mean to indicate that there are SIP 14 facilities. I'm just asking, is it your understanding that Kentucky Power is depending on AEPSC to make that determination to conduct those studies on its behalf?
Yes, Your Honor, we do have the expertise to perform that analysis in a very efficient manner for Kentucky Power. I mean, we rely on the pool of employees that we got to provide that service to the broader footprint of AEP in a very cost-effective manner.
And that would also go with studies of the transmission system's condition. Kentucky Power depends on AEPSC to do those, to conduct those condition assessments.
Your Honor, that's a bit more involved process. It involves a lot of organizations, not just the transmission planning organization. It also includes, by the way, distribution organizations that are within, the umbrella of Kentucky Power. So yes, even though the transmission planning organization, which is part of the AEPSC, is facilitating the process of determining the condition-based needs, there is definitely input from organizations within Kentucky concerning those needs, especially when it comes to distribution assets that are on the transmission line, or the impact of those transmission lines on the distribution service. Those individuals are also part of those meetings and validation of those assets.
And they also depend on AEPSC to conduct those load flow analysis. Is that correct?
Your Honor, I'm assuming you're referring to transmission load flow analysis.
That's correct.
Is that correct? Yeah. For transmission load flow analysis, Kentucky Power depends on PJM as well as on AEP Service Corporation to perform that analysis. Some portions of the analysis, like I mentioned earlier, are performed by PJM. Some portions of the analysis for the non-BES system are performed by AEPSC.
And the same goes for stability assessments and analysis?
Yes, sir, that is correct.
And if I had questions, I'm going to presume I know the answer, but I'm going to ask anyways. If I have questions about the AEP East Transmission Agreement, you would prefer me to ask those of Mr. Vaughn?
Your Honor, actually, that would have been witness corner right before me. I think she would have been the best witness for that type of question.
Okay. My last question is about how things used to be, Mr. Ali, so that I can better understand Mr. Madison's questions today about how things are. You identify those needs on the transmission system and bring them to Mr. Madison as they relate to Kentucky Power. If you identified needs on AEP Kentucky Transmission Company system, who did you directly bring those to?
Your Honor, that would be the exact same process. We would bring those needs to Mr. Madison. And again, as you know, there are very few assets that are in the Kentucky Transmission Holding Company. So as a result of that, number one, and secondly, they're newer assets. So we haven't had any such needs emerge on that very small, limited number of assets population. But if there was anything that comes along, they will follow the same exact process that the other assets in Kentucky, transmission assets in Kentucky follow. We'll take them through Mr. Madison and his staff and seek their direction and guidance to address them.
And is that similar or different across the different AEP East operating companies?
No, Your Honor, it's the exact same process. The affiliates, such as Kentucky Power and Ohio Power, if there are transmission holding companies, those affiliates are responsible for making determination concerning the physical planning, operational aspects of those assets.
Okay. And then
just as they do for their own assets.
And then finally, and this is out of pure ignorance, if Kentucky Power or if an AEP operating company begins to consider the retirement of existing generation, is it your understand? Well, let me take a step back. Is it your understanding, and it's at an extremely high level, Mr. Ali, is that the retirement of existing generation can sometimes necessitate additional transmission?
Your Honor, it absolutely can. We actually had that happen recently in 2012 when there were 7.5 gigawatts of generation retired in the Ohio Valley area. That resulted in close to $1.5 billion of investment on the transmission grid. So yes, it definitely can result in investment on the transmission grid depending on where and how much gets retired.
And when operating companies, in your experience, operating companies in the AEP system consider, or at least even if not actually planning to retire generation assets, but are at least wanting to understand what the impact of a retirement may be, do they find out what generation demand there may be as a result of retirement? Do they find that out through studies you conduct at any point in the process? Or do they depend on somebody like PJM to conduct those studies to determine whether additional transmission facilities may be necessary as a result of that retirement?
Your Honor, it really depends on the, I guess, the accuracy of the information and for what purposes that information is used. If the information is really being used for a high-level planning, then yes, my organization has conducted such assessments in the past. But if the information is being really used for, cost allocation, regulatory filings, then at some point we would have to get PJM to perform that analysis because they, of course, will have the most latest models available and an overall picture of the generation portfolio will be available to them that we probably won't have at the time of the analysis.
And are you aware at any point that did Kentucky Power or Wheeling Power ask you to conduct any of those studies for the Mitchell power plant?
Yes, Your Honor. I was asked to perform such an analysis. From memory, it was, and again, Your Honor, this is subject to check, but it was probably early this year or maybe late last year.
Okay, so within the last approximately 12 to 16 months?
Yes, Your Honor.
Okay. All right, those are all the questions I have. Mr. Overstreet, do you have any redirect with
I have-
Mr.
I have
Ali?
one.
And I'll be frank with you, Mr. Overstreet, it may be, would you like to take a break now or wait until before your redirect or after?
I think I can wrap this up pretty quickly.
Okay, please continue.
Okay. Thank you, Mr. Chairman. Mr. Ali, Chairman Chandler was discussing with you the decision-making process or the decision-making communications between your organization and Kentucky Power, which is Mr. Madison, and then your organization and AEP Kentucky Transmission Company, which, with your permission, I'll call Kentucky Transco. You remember that discussion?
Yes, Mr. Overstreet, I recall that discussion.
Okay. And would, subject to check, would you agree that and I think you indicated that in the case of Kentucky Transco, you dealt with Kentucky Transco management. Do you remember making that statement?
No, I don't remember making that statement. I said in case of Kentucky Transco also, if there are decisions pertaining to the planning of those assets, then, I would discuss those decisions with Mr. Madison and Kentucky Power. There doesn't exist a Transco management, Mr. Overstreet.
Well, would you agree with me that subject to check that the management of Kentucky Transco involves Toby Thomas and Mr. Akins?
Yes, that is correct.
Okay, thank you.
Okay, I'm sorry, I see your point.
Okay. And then,
Overstreet, I just want to clarify that. I was talking from a planning perspective, from a transmission planning perspective. But yeah, you're right. There is a structure where Mr. Toby Thomas and Mr. Akins are the managers of the Transco holding companies, the financial company itself.
And then, thank you, Mr. Ali. And then, one final question. You, at the very end, you discussed with the chairman this study that you performed in the last 12 to 16 months, transmission planning, the effect of the possible retirement of the Mitchell plant. Do you remember that discussion?
Yes, I do.
Okay, thank you. Was that performed at the request of council in connection with anticipated regulatory litigation?
Yes, that is correct.
Thank you. That's all I have, Your Honor.
Are you laying the grounds for an objection if it's requested, Mr. Overstreet?
I'm just trying to make the record complete.
That's fine. I do have a clarifying question based off your redirect, Mr. Overstreet. So I just want to make sure, and it caught me by surprise, and to be frank, I was going to leave here and go check the FERC Form 1. So does Mr. Madison have, well, can we recall Mr. Madison later to clarify the position of Mr. Madison's interaction with AEP Kentucky Transco?
Certainly.
Okay.
Looks like he's still on the line.
Great. All right. Thank you very much, Mr. Ali.
Thank you, Your Honor.
We'll take our, maybe our final recess, and you can call your last witness, and I would like Mr. Madison to come back, because I'd like to ask him that, clarify around his interaction with AEP Kentucky Transco.
And we apologize for any confusion.
Nope, I appreciate it. All right, we'll take a short recess until, we'll take a very short one, 3:30. Thank you. All right, we're back on the record in case number 2021-00370. Mr. Overstreet, you may call your next witness.
Thank you, Your Honor. Our final witness, subject to the recall of Mr. Madison, is Alex Vaughn.
Mr. Vaughn, please turn on your camera, your microphone, and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Alex E. Vaughn. I am at 1 Riverside Plaza in Columbus, Ohio.
Okay. Mr. Vaughn, please pull your microphone just a little bit closer to you. For some reason, it's not picking up particularly well.
How's it?
It's a little better. Mr. Overstreet, you may ask.
Thank you, Mr. Chairman. Mr. Vaughn, by whom are you employed?
I'm employed by American Electric Power Service Company.
And what is your position with American Electric Power Service Company or
I'm
corporation?
the Director of Regulated Pricing and Renewables.
And are you familiar with the areas of, the subject matter areas that you are offered for testimony here today as identified in our October 1, Kentucky Power's October 1 notice of filing a witness list?
Yes, sir.
Okay, thank you. The witness is available, Your Honor.
Mr. West?
No questions.
Mr. Kurtz?
Thank you, Your Honor. Good afternoon, Mr. Vaughn. Mr. Vaughn,
Yeah, and-
assume that West Virginia goes forward with the ELG, and Kentucky, of course, is CCR only. Are there any benefits or cost savings to Kentucky Power through reduced demolition or decommissioning costs, reduced environmental costs with respect to ash ponds, or anything of the like? Any benefits that might accrue to Kentucky that you're aware of?
I don't know. That's not my my subject matter today. I've not been involved in the CCR ELG hearing.
Okay, thank you. No further questions, Your Honor.
Mr. Miller? Ms. Baxter?
No questions, thank you, Your Honor. Thank you, Mr. Vaughn.
Ms. Grunman?
No questions.
Ms. Venzel?
Yes, just one. Good afternoon, Mr. Vaughn. Oh, I'm sorry. You look like you were getting ready to say something. Mr. Madison.
I couldn't hear you there, but good afternoon. Yes.
Okay, we'll start over again. Good afternoon. Mr. Madison deferred a question to you about depreciation rates at Mitchell.
Yeah.
So I'm going to cut to the chase. Do you know if the West Virginia Commission and the Kentucky Commission have approved the same depreciation rate schedule for Mitchell?
I do know that they are different. The rates are different.
Well, since they're different, then how is that allocated?
Well, so you can track what the actual accumulated depreciation is on a jurisdictional basis, and it's pretty common for our multi-jurisdictional utilities to both have, and we have multiple jurisdictional companies at AEP, where you might have one state commission that sets a certain level of depreciation in its rates, and another state commission that sets a different level with different rates. You come up with different accumulated depreciation balances and different amounts of rate base when you file those rate cases, and it's tracked in our accounting organization.
I'm sorry, I'm going to have to go a little lower because I'm a little confused and I want to make sure that I'm correct. So when you say that you're tracking the different rates, is there some allocation to each entity given the different rates?
So expense is one thing, right? Whatever the approved depreciation expense for, right here we're talking about Kentucky Power and Mitchell, whatever the approved depreciation expense is, that's what's going to be in your rate, that's what's going to be on your books. Then when you get to, if you're calculating total plant or total Mitchell depreciation expense, there's going to be a difference. You can't just take the total and divide it by 2 because you have a different rate for each 50% undivided interest. So you would then reapportion it to come up with what is the correct amount of rate base, what is still remaining in plants to be depreciated in one jurisdiction versus another.
Okay, I think I'm following you a little better. And is that reapportionment then tied back to the depreciation rates? I guess what I'm asking is what's the basis of the allocation?
Yes, it would be the depreciation rates, the state-approved depreciation rates.
That was my only question. I have nothing further.
Vice Chair Cummings?
Nothing, thanks.
Commissioner Butler?
No questions.
Good afternoon, Mr. Vaughn.
Good afternoon.
Sorry, I thought I'd be able to sign this before it got to be my turn. So, did you hear my questions to Ms. Connor earlier?
Yes, I was here.
Okay. Have you been part of, or are you aware of the AEP East FRR plan as it's created on any given year?
Yeah, I've been involved with that process for some time, and my group's involved with that, with the operating companies and the other portions of AEPSC that advise the operating companies on that.
Okay. And you interact with Kentucky Power quite a bit in your current job and your previous jobs at the AEPSC, correct?
I interact with all of the AEP operating companies, but yes.
Yeah. Well, and we've only got jurisdiction over Kentucky Power. So let me just ask, are you aware from any of your interactions, whether it be allocated costs, whether it be planning, of any direct interaction between Kentucky Power and PJM that's not necessarily through AEPSC as an agent?
I can't say that I'm aware of that, no, because that's not how we're set up. We have for example, when we're talking about capacity planning and the FRR plan, we have subject matter experts here at the service company that provide those expertise to all of the East companies, well, all of our companies, but the East companies specifically when we're talking about PJM and capacity planning and FRR plan, so that you don't have to duplicate that expertise and those full-time employees in every single operating company. So we have that group of people that then advise all of the operating companies in question, who then make the decisions back to those folks at the service company that are the subject matter experts that then deal with the RTOs.
Yeah, don't take my question as being as implying a concern or a disagreement with the process. I'm attempting to try to find out, the facts and the reality of the situation as to how much. Well, so let's take a step back. Kentucky Power operates the Mitchell plant, correct?
That's correct.
Do you know if Kentucky Power directly takes their dispatch direction from PJM, or whether or not that comes through the AEPSC?
Yeah, I know they don't. It's a centralized group, the generation dispatch team at AEP Service Corporation, that dispatches all of the AEP-owned plants, east and west, provides those market offers and all of that, on behalf of all the operating companies.
Yeah.
So no, it's not a Kentucky Power employee taking the dispatch instructions from PJM, the service company.
And there's no distinction between that situation between Mitchell and Big Sandy 1, correct?
Nope, all the same people.
And then how about you're aware of the AEP East Transmission Operating Agreement, correct?
Yes, generally from a cost allocation standpoint.
Yeah, and that's what I was actually going to ask questions about from a cost allocation perspective. PJM doesn't direct charge Kentucky Power for transmission expenses, correct? They don't send a bill to
Actually
Ashland?
does.
Is it your
It
understanding,
does.
do they send a bill to Ashland, I guess is my question.
Kentucky Power receives a bill from PJM for its transmission costs as an LSE. Those costs for all of the companies that are party to the AEP transmission agreement are then aggregated and allocated amongst the companies per the FERC approved cost allocation in that agreement.
Right, but
So yes, yeah, they receive a bill and then it's reallocated and accounted for.
yeah, so but that's AEPSC receives a bill and then reallocates that bill to the operating companies, correct? To the LSEs.
Yes, the bill says Kentucky Power on it, but yeah, it comes to the service company.
Okay. Are you aware? Are you aware if I apologize, Mr. Vaughn, the way things are in my head are not necessarily understandable to other people the way they are in my head. So you'll have to give me a second.
No worries.
In your current position or your previous positions, did you or do you convey information back? Do you communicate back and forth with PJM on behalf of Kentucky Power or the other PJM operating companies?
I have not directly interacted with PJM in about 4 jobs, so
Okay.
it's been a while.
So do you know though, 4 jobs ago, and congratulations on that. I think I've had a total of 4 jobs. So 4 jobs ago, that interaction, what I'd like to understand is when AEPSC, from sort of the, well, let me take a step back. What were you doing 4 jobs ago?
That was an approximate number, but the last job I had at AEP, where I directly communicate with PJM, is when I was the lead settlement analyst for the AEP's companies in the PJM market. So when the RTO bills came in, myself and the other analysts settled that activity with PJM and conversed with PJM analysts when there was whenever we had a question on any settlement item.
Yeah, and that's a good one. So the interaction with PJM, so that would have been Kentucky Power as both an LSE and as a generation owner. Is that right?
Yeah, back then it was even more complicated because we were still in the old interconnection agreement or the AEP pool. So everything was still one large group of activity in PJM. It wasn't even split out by operating company. It was all pooled together as the AEP East.
Yeah, and so what's your experience on? So you were the go-between for AEPSC to PJM. What was your interaction or your group's interaction following that interaction with PJM with Kentucky Power itself?
Those interactions would generally be, again, I was the settlement accounting function, so to the extent Kentucky Power had or any of the operating companies had a question about some charge to their company, something that hit their P&L, we would be the ones to help, describe that variance or anything that went against what they were expecting.
Yeah, so you did the settlements. I would expect that the information that you gleaned from that position as an analyst, and that you get the back and forth between you all and PJM, that helped inform subsequent filings here at the commission, whether it be fuel adjustment clause filings or off-system sales. Is that fair?
Yeah, that's fair. That's all that market settlement activity and the subsequent accounting goes into various cost recovery filings. That's correct, which led me to where I am now.
Yeah, and so is that interaction, is that more of you sending the information, or did you have particular people at the company, whether it's in the regulatory piece or in the accounting department in Ashland or in Frankfurt? Where was your interaction with Kentucky Power?
It was generally, back then, it was generally in discovery and cost recovery proceedings. If they're doing monthly budget to variance reports, why is this account out of line? And if it was a PJM market account, we could help answer that. It was really hot, you had more load, so this charge was up, or something to that effect. But those types of interactions.
Yeah, and so this may sound like an odd question, but in positions like that, was the information necessarily pushed from AEPSC, or was it pulled from Kentucky Power?
I don't think I understand your question.
Yeah, so and I know it's an odd way to characterize information, but when your settlements ended each month, or each week, or each day, or whatever period it may be, did you by default automatically send that information on to a person or people at Kentucky Power, or on a recurring basis did they request that information for their purposes?
Yeah, I think it's both, and it still is. There's, when things get settled, there's distributions that happen. Emails go out with reports, and folks get monthly accountings of things, and then you'll have operating company employees who are, actively engaged in some sort of cost recovery filing with open discovery, asking, hey, what happened here, and can you provide backup for that? So it's a two-way street of communication.
Okay. Do any of the operating companies in your experience do they have varying levels of expertise in things like settlements, or is the experience pretty much expected to be at the AEPSC level, and to be for the AEPSC level folks to be the subject matter experts on those issues?
I mean, they could have some of that experience. Just depends on how people move around the company, around AEPSC, around the operating companies. But those functions sit here in the service company, like the market settlements, or I guess what my team does. Those sit here, and we provide those services to all the operating companies. So it's a mixed bag.
Yeah, and I asked from the perspective of, has it been your experience that any of the operating companies have explicitly identified a go-between that has if you all speak a different language effectively, has put somebody there as the ombudsman or as the translator specifically to what you all do, that has that experience, so that the operating company is informed as to what the information you all are sending means?
Yeah, I think that's fair. There's definitely that. If I was gonna make a generalization, I'd say that's probably sitting in like that rate director role at the operating company. Mr. West's last role, those folks generally have a pretty good feel for a translation of what's coming from service company, from those activities that they are then responsible for dealing with in cost recovery filings and other regulatory filings. So, yeah, generally speaking, there's someone there.
You've been asked questions about this, and I think in some of the other cases, and I don't know, to be perfectly frank, if those cases are the ones that I've asked these questions in, are the ones that are incorporated in this case or not. So I'll just ask them. Do you know of the other entities, the other operating companies that are part of that power? I'm going to forget the exact name, Mr.
Coordination agreement.
Thank you. Do you know whether they're long, short, or have adequate capacity related to what their requirements from PJM are?
I do. None of that is public information.
Say that again.
I do, and none of that is public information.
Okay. So would you like to move on to the confidential portion. What I'm asking for is, in that agreement, which applies to Kentucky Power, is whether Kentucky Power is being leaned on or Kentucky Power is leaning. Do you know what I mean by that?
Yeah, I think I can explain that without going into a confidential session. The agreement is such that if there is a, let's say here, so the FRR plan in total is sufficient, right? So it meets all of the companies, which is, to be clear, all of the AEP East fully regulated, vertically integrated utilities. So you have Appalachian Power Company, Kingsport Power Company, Wheeling Power Company, Kentucky Power Company, Indiana Michigan Power Company, and Wheeling Power Company. They're all included in there. So the FRR plan accounts for all of their total LSE obligation and the reserve margin on it, and has the supply resources from all those companies that they control. And when we we make the FRR election and file a FRR plan, it is sufficient, meaning that it covers those obligations and the required reserve margin. If the plan is sufficient and length still exists, the company can make excess sales into the PJM base residual auction and other incremental auctions, which the company does on behalf of the operating companies. And per the PCA, those sales are proportionally allocated to the companies that do have length. So when Kentucky Power is long and the pool makes sales, which it traditionally has been, Kentucky Power gets its allocated share of said sales.
Right,
It's covering its obligation, and then it's getting paid for its length that can be utilized.
Right, but my question is around, if Kentucky Power or another operating company is long and another is short, is the plan in aggregate, or is the plan on an individual operating company basis?
So it's both. The plan is in aggregate. We're covering the total obligation, and somewhere in Section 7 it says every company is going to plan for its own obligations, and just leaning on everyone else is not planning. There may be ups and downs, small hiccups in positions, right? Because capacity positions can change based on loads that come and go, and the overall performance of the fleet of assets, right? Because the UCAP is based on plant performance. So that you can have year-to-year fluctuations in those numbers, and those fluctuations can get settled out between the companies. So no one is right now long-term leaning on or taking advantage of anyone. That's not how we plan this. It's I can tell you, I've sat through these meetings where all the OpCo presidents are there that represent a company in the plan, and the positions are laid out for them. Here's where everyone stands, and here's the recommendations of the subject matter experts at the service company, and it's discussed by the OpCo presidents, and they all agree on the course of action. That's how it moves forward.
So Kentucky Power is, as I understand it from the most recent IRP, is currently long. Whether that's the case after the UPA expires is, I think, yet to be seen. I don't know where we are in what delivery year, planning year we're in now with PJM. But what benefit is Kentucky Power getting by being part of this plan versus asking AEP-SE to create its own FRR plan for Kentucky Power?
Yeah, it's a good question. So when you think of capacity, I guess the capacity construct in PJM, right? And we are in the era of what I'll call capacity performance, right? So if there's a performance interval leveled by PJM, there can be some pretty, and you don't perform, there can be some pretty stiff penalties if you do not perform. So the benefit Kentucky Power and all of our operating companies receive by participating in a combined FRR plan is that there is a diversification of risk when we are covering the whole FRR obligation from a diverse amount of resources of each of the operating companies. We are able to manage those ups and downs of unit performance. Whereas Kentucky Power, if it was just sitting in its own FRR plan, which is possible, it could be in its own FRR plan, it is purely tied to the performance of the Mitchell plant, Big Sandy 1, and whatever other resources it would potentially have in there, if it added resources in the future. So you're going from a larger pool of resources where you can move things around to avoid penalties to, a smaller pool. We also are able to, as a fleet, as a pool, insure against certain risks because we very, very competitive rates because you can diversify those risks across a larger number of assets and units.
So do you have a copy of that agreement?
I do. I have the one printed.
It may be nice and warm after it was printed.
Yeah.
Specific to what you were talking about, I think that, do you mind to turn to sheet number 20?
I am there.
Okay. And so sheet number 20 under, do you see delivery year and post-delivery year settlement?
I do.
I've never used the word settlement more than I have in the last 30 minutes, Mr. Vaughn. Just a small little note there. The second paragraph that starts with if capacity resource performance charges, do you see that?
Yes.
And that's those capacity performance assessments that you were discussing earlier. Is that correct?
Yeah, I think this is a broad characterization because I think the actual charge name has changed over time from when this document was made. But yes, it's referring to resource performance penalties.
Okay. And so it says here, as I read it, if capacity resource performance charges are assessed by PJM for a given delivery year, the total net charge will be allocated among the operating companies ratably in proportion to each operating company's contribution to the total charge, taking into account the effect of collective participation of the operating companies and the fixed resource requirement alternative. Did I read that correctly?
Yes.
Okay. And then it goes on to say that each operating company's contribution to the total net charge will be determined by the agent, which is AEPSC in this agreement, by computing a total megawatt position for each operating company by subtracting its total capacity obligation in megawatts from its total capacity resources in megawatts. And then it goes on to note how it'll be further adjusted by adding or subtracting, as applicable, the net total megawatts of actual underperformance or overperformance of each operating company's capacity resources during the delivery year as computed by PJM. So does this say what you were just saying, is that it spreads out that risk, or is each operating company responsible for the capacity performance charges that it causes?
So it's saying what I said because it starts with if capacity resource performance charges are assessed. And my point in the strategic advantage in the collective FRR plan is that you can avoid having these penalties assessed. You have a greater likelihood with a larger pool of assets from having any charge. What this is saying, though, is if there is still a charge in that total pool, and let's say you have, in this example, there is a charge assessed to the FRR plan, and Kentucky Power's assets ran completely fine, I&M and APCO's underperformed. So it's going to say, for these words here, you wouldn't expect Kentucky Power to be allocated any of that because it did not underperform. So if there was a 10 megawatt underperformance and APCO was on the hook for 2 of that and I&M was made up 8 of that, based on these words, that's how the charge would be assessed. My whole point is that we can avoid the theory behind the collective FRR participation is avoiding that charge for all the companies from the get-go.
So which of the units that are included in the plan are not going to be subject to capacity performance and therefore will receive bonuses?
It doesn't work that way. In your FRR plan, you can comply as a total fleet, not as a unit by unit. That's one of the advantages of FRR versus being out in RPM.
Okay, so you're saying that each one of the units is provided on its UCAP basis, correct? It's rated in each
One
year.
thing, you have operation is operations, right? So performance is performance. If there is an event and you have enough resources in your plan to meet your obligation, there's no charge. However, you could have a unit that underperforms and one that overperforms, and you can net inside the plan. If you were out in RPM, the underperformer is going to be assessed a penalty.
And that's what I want
For our plan, we're not.
Yeah, when I asked about UCAP, I'm asking about the baseline that it's compared to, right? So the plan is based off of the unit's UCAP, correct?
Yes, that's correct. Going into the delivery year, you have to have a plan where you have enough UCAP megawatts of resources in your plan to meet your UCAP megawatts of obligation.
And you're saying the benefit from your perspective is that insofar as certain resources underperform, and you mean underperform relative to the UCAP, the UCAP baseline for that year's plan, is that what you mean by underperform?
No, this is talking about a resource performance charge. So once you're in the delivery year, right? If there's no, let's say there's no performance intervals brought up by PJM in that delivery year, and you do have units that underperform, there's nothing to be judged against. There's no potential charges there. But where it's going to manifest is in the next year, you're going to have less UCAP from those underperforming units to use in your plan, right? It goes up and down based on unit performance. But then conversely, if you do have a delivery year where you have PJM calling performance intervals or capacity performance events, and you have underperforming units, there's a possibility of a resource performance charge or a capacity,
And you're referring to performance assessment intervals. If PJM calls a performance assessment interval, which I think are 5-minute increments now, if they call one of those, my question was, if they call one of those, the terms you're using, underperform and overperform, are you indicating that that's underperform and overperform on a specific unit basis as compared to the UCAP that's included in that plan that year for that unit?
That is one step below, further into the weeds than I can answer today. But that's, I'd say generally yes. Whatever that you can have units that underperform and overperform based on what they are, what they have committed.
Okay.
I believe it's UCAP, but I would need to check that with our experts that deal in those actual transactions and the management of those positions.
Okay. That's all I have, Mr. Overstreet. Do you have any redirect for Mr. Vaughn?
May I speak to Ms. Glass just
Sure.
one moment? I have no redirect, Your Honor.
Okay. Thank you very much, Mr. Vaughn. You may be excused.
Thank you.
Mr. Madison.
Okay. Mr. Madison, are you still here? And do you mind I think your phone may still be muted, Mr. Madison. Still can't hear you. Sure, I see, I think you're gonna try to dial back in, so just take your time. I think we can hear you now. Can you say something, Mr. Madison?
Can you hear me now?
We can.
Okay, good. For some reason, I lost audio, so dial back in. Okay, good.
As opposed to everybody that's in the hearing room in Columbus, we can hear you just fine, Mr. Madison. So it may be easier. Well, I'll give you an opportunity, Mr. Overstreet, given the questions that were asked and maybe the confusion that was indicated. Would you like to ask Mr. Madison any direct, redirect based off of the other witnesses' testimony, or would you like to go ahead and proffer?
I think I would prefer to proffer.
That's fine. Mr. West, do you have any additional questions for Mr. Madison? Mr. Kurtz?
No.
Ms. Baxter? Mr. Miller, any additional questions for Mr. Madison based off the rest of the testimony we received today?
No. Thank you. Oh, sorry, actually, Bethany, one or two. Hi again, Mr. Madison, how are you?
I'm good, thank you.
Good. I just wanted to circle back about the application for declaratory order, which was discussed a little bit after we spoke.
Excuse me, Mr.
Hold on a second, Mr. Miller, please.
We brought Mr. Madison back to address the issue that arose concerning the Transco. I don't think it's appropriate to redredge up the discussion that we had for an extended period this morning.
Yeah, so Mr. Miller, the limited purpose of the reason we recalled Mr. Madison is discuss items that have subsequently come up since Mr. Madison's testimony. Do you have any questions on those items for which testimony, cross-examination was conducted for other witnesses that you didn't get an adequate answer from the others, or confusion that arose that only Mr. Madison can respond?
Yeah, Your Honor, I think I can let the line go. I thought that Mr. Madison had referred us to Mr. Spitznagel on some of the legal questions underpinning the application, and that's why I didn't ask at that point. But it's nothing that wasn't addressed in Sierra Club's response to KPC's application, so I can just refer the commission to that written response, and that will be just fine. Thank you.
All right, thank you, Mr. Miller. Ms. Grumman?
No, Your Honor, I don't have any questions that need to be asked today.
Thank you. Ms. Vincel?
No questions.
Vice Chair?
I do have one question that's a follow-up to something this afternoon. Hello again, Mr. Madison.
Hello again.
Getting back to the operating committee, I believe it was stated earlier that you are the designated member of the operating committee for Kentucky Power. Is that right?
That's correct.
Do you recall if there were any discussions among the operating committee regarding incurring costs for ELG compliance?
None that we had about ELG costs, simply because we were awaiting the hearing, which we received in case 2 with CCR only, so we have not discussed anything in regard to ELG costs.
Okay, that's it. Thanks.
Commissioner Butler?
No questions.
Okay. Mr. Madison, I think you may know what my questions are, or related to the AEP Kentucky Transmission Company. Do you have any relationship to the AEP Kentucky Transmission Company in terms of setting the budget or directing the investments of that organization?
No, I do not.
Okay. That's all I have.
No,
Mr.
no
Overstreet.
redirect.
Okay. All right. Thank you for sticking around with us, Mr. Madison.
No problem at all. Glad to.
Which brings us to the rest. As I understand, in terms of items that are outstanding, you've certainly filed the application for a declaratory order And therein, part of the prayer for relief is a request to effectively dispense with the regulations that will require it be filed as a separate application, is my understanding. Is that right, Mr. Overstreet?
That's correct. That was that first footnote.
And I don't believe there are any outstanding petitions for confidentiality, but there is the outstanding date, and it's going to escape me right now, Mr. Overstreet, that the company has the opportunity to file that petition for the formal conference. Is that still your intention at this point to file that, or have you had a chance to review?
We are still reviewing, but and to the extent, we will file something one way or the other,
Okay.
so that the commission knows.
Okay. We have, as I understand it, yesterday you filed your newest notice of filing, in this case, an update to a data request in the 2021-00004 docket, the CPCN EOG CCR proceeding, providing your 10-day update. Is that right, Mr. Overstreet?
That was filed yesterday, correct?
Okay. And so the next update on that would be October the 14th. Is
That's
that
correct.
correct? October the 14th is a Wednesday, Thursday. That will be one day happenstance. That will be one day after, I think we expect at the latest, the West Virginia Public Service Commission to rule on the proposal by Wheeling Power Company. Is that your understanding? That we expect an order by the 13th?
Right, I think the hope was we'd get it before, that Wheeling would receive it before the 13th, so
Okay.
a decision could be made in time to file something on the 13th.
And that was what Mr. Spitznagel, I think, was referring to today, is that their decision point at the 13th. Is there any, I'll just ask it this way, is there any motions or requests that we need to take at this time, given we're happy to take them orally and be supplemented in writing, but we don't have much time. Let me just take a step back. You've requested an order, the company's requested an order on the application for declaratory order by the 8th. I won't speak to that at all, especially since the regulation is certainly permissive as to the commission's position on it, or what the commission's actions have to be. But as I see it, the proposals that have been put forth in front of us are October the 8th, then by October the 13th is when we expect some decision out of the West Virginia Commission. And then Mr. Spitznagel has referred to that October the 13th date in which the company, Kentucky Power, has to notify the regulatory authorities in West Virginia, environmental authorities. Other than those pressing dates, the only other one that I'm aware of, Mr. Overstreet, is the one in which the company needs to file something related to that formal conference. Does anybody have anything else that needs to come before us today, given those deadlines? Beyond those deadlines, it's a, what do they say? It's a sprint and then a marathon, as far as I'm concerned. There's a lot of things that we intend to do in this docket after the initial dates are passed, but is there anything that we need to take under advisement today?
Well, Your Honor, and to the point of our application for a declaratory order, the 13th, as you recognized, is a week from tomorrow. And Wheeling and Kentucky Power are going to have to make a decision, and it would obviously aid that decision-making process if Kentucky Power and Wheeling understood the Commission's position on the question of whether Wheeling needs to come in to this Commission and seek some sort of authorization with respect to the CCR ELG option. And I think the consequences are significant, and so we would urge the Commission to do what it could to provide that clarity.
And I can ask this now without you testifying, since you're effectively arguing in favor of your motion or application, your prayer for relief. It was my understanding today from Mr. Mattison's testimony that the impetus for making that request was seeking clarity around the Commission's order where it wasn't specific to Wheeling Power needing a CPCN, but the reference in the same sentence to both CPCN and Wheeling Power and ELG. Is that your understanding for the impetus of the application and the concerns surrounding Wheeling, a CPCN, and the ELG?
So Wheeling and Kentucky Power is the operator, has to make a decision on or before the 13th. And the question is, does Wheeling or Kentucky Power need any other authorization from this commission to elect the CCR ELG option?
But, counsel, if I may, you asked just now, does Wheeling or Kentucky Power need anything else from this commission, but your motion only addresses Wheeling.
Right, Madam Vice Chair. The application addressed is Wheeling because that was our understanding of what the question was that was posed at the formal conference, the question that was posed in the September 15th order. And we're looking for clarity. And to the extent that the commission can provide that clarity, that's what we need.
And I think that's where I'm confused now, because now I'm lacking clarity on what we're being asked to do by the 8th.
Well, our application indicates that it was our understanding, or was addressing the issue of whether Wheeling, because needed authority from this commission to act. We indicated in the application that we didn't believe that the commission, having already ruled on our application to do both CCR and ELG, that issue was open, but we're just trying to get clarity here. We want to act consistent with the laws of both jurisdictions to the extent we can, when we have to.
Well, and I can appreciate the concern. I think I didn't understand until today where the concern from Kentucky Power was coming regarding whether Wheeling needed to receive a CPCN from this commission. Because I'm unaware of an order that said that, or that indicated, and if I said it from the bench, I certainly misspoke, that was the concern. But I think the order discussed, and I have, I think, a copy and paste from that order, a bullet point of different items, one being, quote, the need for a CPCN even if West Virginia PSC approves Wheeling's petition. Right? But I just took today from Mr. Madison's testimony that he read that as the need for Wheeling Power to get a CPCN from this commission, even if West Virginia PSC approves Wheeling's petition. That was my impression of what Mr. Madison's testimony today was, that he read, how he read that.
And that was my understanding too.
Okay.
In light of the fact that, what's pending in front of the West Virginia Commission is a request that the West Virginia Commission declare that in the event that the ELG work proceed, that Wheeling would be responsible for the cost of that ELG work.
Okay, because as I understand it, Mr. Overstreet, Wheeling has already received a certificate that the public convenience and necessity of the West Virginia Commission demands the projects needed to comply with both CCR and ELG. Is that also that they already have their CPCNs from West Virginia?
Wheeling has its CPCN to proceed with both CCR and ELG from the West Virginia Commission.
Okay.
And perhaps maybe we could cut this Gordian knot if the commission could provide further clarity on what that phrase might be, that clause might mean. The need for a CPCN even if West Virginia PSC approves Wheeling's petition.
Okay. My final question was around this, and I could have asked Mr. Madison, but is to understand that that the basis is The basis for the application is exclusively related to this commission's orders, and I guess I'll take the vagueness of its statements, and not some concern or direction from anything that's happened in West Virginia, whether it's another party that has said, well, we think it needs X, or whether their staff has said something, or whether their commission has ordered the utility to, their utility, to determine what is required of this commission. That's the other thing I wanted to ensure.
Right, I think that it's our reading of the Kentucky statutes that Wheeling would not require the CPCN. And I think both Kentucky Power, Wheeling, and to the extent that I understand what happened at that proceeding, everyone just wants to make sure that the Kentucky Commission does not have a different opinion on what Wheeling needs to do to proceed with CCR ELG.
Mr. Counsel, on page 9 of the motion, in paragraph 19, you're there that part of the impetus for this motion is indeed a concern on behalf of the West Virginia Commission that Kentucky needs something, or needs to issue something for the work to proceed. I struggle to figure out what that is after having read the hearing transcript in West Virginia.
Well, at the time, I'm sorry, I didn't mean to cut you off, Madam Chair.
No, that was done.
Okay. This application was filed before that transcript was available. This application was filed last Wednesday. The transcript became available on Friday. But it was our understanding, based on the notes taken by counsel at that hearing, that that the West Virginia Commission staff had was seeking, not seeking, that's not a fair term, that there was a perception that of a need to clarify what the Kentucky Commission understood Wheeling's obligations might be to the Kentucky Commission if they were to proceed with the CCR ELG option, and it's our further understanding that that was in response to that clause that we've been discussing in the September 15th order. But
Okay.
Chairman?
Yeah, I was gonna, Mr. Overstreet, do you have anything else on this?
no,
Okay.
not at this point.
I just wanted to make sure before we took the temperature of the room. Mr. West, do you have anything on this issue? I know that Mr. Miller has filed something in writing and I guess reserved his right, should we ask him to say something today, but do you have anything on the application?
No.
Mr. Kurtz?
I do, Your Honor. I hesitate, but I will. I've reviewed the petition for declaratory order, and without doing extensive research, it seems to me that Kentucky Power is correct, that the West Virginia utility does not need permission from this commission to build an ELG or comply with ELG on a West Virginia power plant. That said, I think the commission has 100% jurisdiction over the actions of Kentucky Power as the operator of the plant, whether Kentucky Power acted prudently and whether or not that led to unreasonable costs being incurred by Kentucky consumers. So I think that's where the commission's jurisdiction is completely strong on the prudence question, not on the certificate question. So that's the legal. As a practical matter, if West Virginia goes forward with the ELG and Kentucky Power is held harmless in terms of no ELG costs will go to Kentucky and no other additional CapEx, like that $30 million that Mr. Becker was describing of additional things that could benefit Kentucky. As long as, so legally I think the company's right. As a practical matter, as long as Kentucky Power is held harmless, then they're held harmless. And as a practical matter, if the Mitchell plant is sold to Kentucky Power, it's sold by Kentucky Power to West Virginia, to Wheeling, then there would be a positive benefit to Kentucky consumers, because getting something from Mitchell would be better than getting nothing from Mitchell, which would be the case with a 2028 retirement. Mr. Madison indicated that the purchase price may be at comparable sales analysis, in other words, fair market value, but that is better than getting nothing. So where I come down for KIUC on this is legally, I think the company is correct. I think the commission retains its prudence jurisdiction over the actions of Kentucky Power. I think as long as Kentucky Power is held harmless as to the cost of ELG, that's good, we're no worse off. And if the plant could be sold to Wheeling, then we're better off.
Mr. Miller, anything in addition to your filing I think you made last night?
Your Honor, nothing additional. If I may just very briefly say, Sierra Club would concur with what Mr. Kurtz just said. We do not disagree that Wheeling Power is not required to come before this commission for, approvals for things that it may do that exclusively affect West Virginia rates, West Virginia customers. So to the extent that the application seeks only that statement, we don't have a problem with that underlying contention. But if there are new arrangements, transactions that may be proposed in the near or future or otherwise, to this commission, based on developments, the discussions at AEP between KPC and Wheeling, if there are, new proposals that Wheeling decides it wants to go forward and gets approval in West Virginia, but those are based on new arrangements that do impact Kentucky customers, we would ask the commission make clear that it is not dispensing with the possibility that KPC may need to get authorizations, whether in the form of the CPCN or otherwise, in the future for any such proposals, transactions that may be proposed and that AEP may be thinking about. So that's spelled out more concisely in the response. But we think that's an important caveat to any ruling or any relief that the commission may order.
Ms.
And we
Grundman?
think Wheeling and others should be aware of that.
All right, thank you, Mr. Miller. Ms. Grundman, anything?
No, Your Honor, Walmart doesn't take a position at this time.
Mr. Overstreet, anything?
Just to Mr. Kurtz's point of, to the extent that there are expenses, CCR expenses incurred by Kentucky Power, then of course the commission has the ability to review them through our environmental surcharge filings in the future. And to the extent that there's any sort of capital investment that was to be recovered in Kentucky Power's rates with respect to CCR, then the commission, of course, would have that ability in any future rate case.
Yeah, okay. I think that one of the rubs, as I see it, is this Mitchell operating agreement. Had people tell me that anything longer than a one-page contract is unnecessary. The longer I'm around things, I realize it's not the case. You need to envision as many possible scenarios as possible when drafting something of that significant consequence. And there's certainly going to be some changes one way or another that have to be made as a result of either commission's here or West Virginia's ruling as it relates to the cost.
In Your Honor, I would just remind the commission of, I think it's Article 7-9 of that operating agreement and the ability of one of the two owners to make investments solely for that owner's benefit. And
If the other one hasn't already agreed to include the costs in the annual budget. I take that under advisement, Mr. Overstreet. Vice Chair, Commissioner Butler, is there anything else?
Nothing from me.
Nothing from me.
Ms. Vincel, anything?
Nothing.
So we'll take your, I guess your oral request to thoroughly consider the application under advisement, Mr. Overstreet.
Thank you, Your Honor.
I assume no interest, no, I'm unaware of anybody today that mentioned that they would have any post-hearing data requests. Is that your understanding, Ms. Vincel?
That's correct.
Your Honor, sorry to interrupt you. Earlier, you were asking for upcoming dates, and you were asking if there were any other on the horizon. The September 27th order also does contemplate a memorandum brief regarding the time period that should be provided for notice by October 15th.
Oh, that's right.
And we'll file that.
Okay. I appreciate that. As part of that, don't have to, but I'm just requesting. If you had an affidavit from somebody like Mr. Bishop or someone else at Kentucky Power that regularly requests proof of publication and publication, public notice ahead of hearings, that could indicate, I know there's a lot of counties, let's just, I get that. But indicate what the ordinary timeframe is that they require, the Kentucky Press Association requires notice in order for it to run in all those publications, assuming everybody does it upon receipt and doesn't forget. I think that would be very helpful to our consideration about how these processes will move forward.
And this relates to the no later than 7 days prior to the hearing and no further out than 21 days. That statute, that because that's the problem, getting it in that window.
Yeah, yeah.
Okay.
And really just, how much time, once the Press Association is aware of it, how much turnaround time is there for them to notify each one of the newspapers of general circulation, and then once those newspapers of general circulation find out how, most of these are weeklies. I grew up in a county that only has 2 weeklies, but they're still only once a week. So, how quickly public notice can be provided in order for the commission, in order for the public to know that there is going to be a hearing on a particular subject in enough time in which they can watch or even participate or comment.
And then the other thing I would point out, and we'll get some information on this, that and we're coming up on the holidays, a lot of newspapers don't publish the week of Thanksgiving or the week of Christmas, so that can cause a hiccup also in the publication schedules. As Mr. Bishop is always quick to remind me.
As long as there's somebody that's knowledgeable about it, we would appreciate, some sort of assertion on that front.
Okay, thank you.
Okay. Hearing anything else? Nothing else? Ms. Grumman, anything?
Your Honor, I briefly got kicked off, so I don't know if in the last 2 minutes you've set any dates for anything. I did actually have a question. I think earlier in the hearing, you had on some cross-examination indicated that this may be the first of maybe a future set of hearings. Did I misunderstand your questions on that?
You did not. This case is young.
And I was just curious, I was not aware that any dates had been set and was just curious as to whether somehow I had missed a future date being set. I had a number of hearings coming up and wanted to make sure I didn't miss any.
No, the only dates that this commission has set were included in the order on September the 27th. On September.
I have that order, yes, Your Honor.
Otherwise, we've not set anything specifically moving forward. I think, like I said, it was a rush to get hearings in so that we could be adequately informed prior to what we expect the West Virginia Commission to take action. And then after that, I think that the rush, insofar as there is one, at least slows down a bit.
Understood, Your Honor. Appreciate that clarification.
Okay. Hearing nothing else, we'll adjourn. Thank you.